consolidated matters in the matter of the Democratic Alliance and the Minister of Public Works, Infrastructure and others, AfriForum and the President of the Republic of South Africa and others, and private land splitting and the President of the Republic of South Africa and others.
Good morning, everybody.
Good morning.
Start now.
May it please the Court. Judges, we are going to split our arguments into two sections. I will be making the arguments about why the correct interpretation of the Constitution forbids nil compensation. And then my learned junior, Mr. Paramasani, will be making arguments about why Section 12.3 fails the rationality test and why international law would also forbid the payment of nil compensation. I will start off by saying that many of the arguments made yesterday by our learned friends from SPOC are similar in nature to the arguments that I intend on making today, but I will try to avoid repetition. We take the view that a proper interpretation of Section 25.2 means that you have to accept that words matter, that every word that is in the Constitution is there for a reason, and that means that you must take note of the words payment, amount, and compensation. Now, my learned friend for IR Legal started off by saying that nil is a number, 0 is a number. Now, there is a difference between a number and an amount. So there are negative numbers. -7 is a number. But it is not possible to have an amount of a negative number. One cannot go to a grocery store and they would have a sign saying we have -7 apples. If you ask them, do you have an amount of apples in the store, and they said yes, that amount of apples is 0, it would be an incoherent statement. An amount must be a positive number. You have to be able to possess an amount, and you cannot possess the absence of an amount. So nil is the absence of something. Nil compensation then is also no compensation or the absence of compensation. And payment requires being able to pay an amount of money. It is not possible to pay someone with a check that has a negative number or a number that has 0 written on it. And compensation by its nature entails that you are rectifying a wrong, and so it is never possible to compensate someone with nothing. Judge Saldana, you made a point yesterday, which is that there's an additional modifier to compensation, which is just and equitable. Now, obviously, if compensation always entails the rectifying of a wrong, then that can never entail 0, by the nature of what compensation means, and 0 can never be amount, and one can never pay 0. It is also the case that it is never just and equitable to take someone's land and give them nothing. Giving someone nothing in those circumstances amounts to confiscation and not compensation. If we think back to our dark past of land dispossession, and the court was right to mention this terrible history that we have of the National Party government, of centralized governments, exercising powers to take land from people and to give them nothing. That is a mistake that should never be made again. And it would be no solace at all if the apartheid government, after kicking people out of land that they owned in District 6, let's say, then said, don't worry, your compensation check is in the mail. And when you open the envelope, the check says 0. We would think that that would be adding insult to injury. That would not be compensation at all. That would be a destruction of language and a further injustice. Now, one of the questions that was raised by the court was, could it be possible to pay 1 rand in compensation? I think there are two things that can be said about this. Firstly, the Act only references the word nil compensation. So there's a sense in which the question of whether R1 is permissible is not really a question before this court. But I would also say that if it were a question before this court, R1 is an amount that can be paid, but it could not be compensation because it is nominal in nature, and compensation requires something substantive, as does just and equitable. Now, it might be the case that one could continue to add rands. So you could say, well, 10 rand, 100 rand, 1,000 rand, 10,000 rand. And at some juncture, we may get to an amount where we can say we accept that that is compensation. That is just and equitable. And it may be hard to draw that line. But there's a famous ancient Greek case called Sorites paradox. The Sorites paradox, which is that if you have 1 grain of sand and you add a grain of sand to it over time, eventually you will reach a pile of sand. And it's not possible to say when one has reached the pile, but we know that there is a difference between a single grain of sand and a pile of sand. So the fact that there is some ambiguity in between doesn't mean that there is no distinction. And so there is a distinction between compensation and nominal amounts, and it might be that it's difficult to draw the line when it crosses over. But that exercise will not be done by this court. It will be done by a court dealing with a particular expropriation before it, and we'll have to determine based on the facts before it, have we now got an amount that actually amounts to genuine compensation? That number can never be zero, and we say it can never be a nominal amount. It must be genuine compensation. We also think that it matters when interpreting the Constitution to take into account that there was a consensus between the negotiators of the Constitution, the ANC and the National Party, about what that clause would mean. There was an agreement that there is a distinction between deprivations and expropriations, that when a right of property is deprived, that doesn't entail an obligation on the state to pay compensation, but that when there is an expropriation, that does trigger an obligation to pay compensation. And there was complete consensus over that point, and that was recognized by the Constitutional Court in the certification case. Now, there was an attempt to change this state of affairs. There was dissatisfaction with the idea that one must pay compensation when expropriating land. And so there was an attempt by Parliament to change the Constitution for our first time with the Bill of Rights for the first time. It would be the 18th Amendment, to remove the right of compensation. And there was vigorous debate for many years, and eventually there was a vote, and the attempt to change the Constitution to allow for expropriation with nil compensation or no compensation failed. And we say that that matters. It matters because it means that the Constitution as negotiated and as we currently find it does not allow for nil compensation or no compensation. What we have now is a piece of legislation which attempts to circumvent this, that knowing that the Constitution does not allow for no compensation or nil compensation, that there is nonetheless an attempt to achieve this end without the necessary mechanism to have that, which would have been a change to the Constitution. If the Constitution had been changed, if the threshold had been met, the 2/3, then there could be an argument that this legislation was constitutional because the Constitution had changed. But given that that change failed, it must be the case that this legislation is unconstitutional. It also was passed at the lower threshold, that 50+1, whereas our Bill of Rights requires the 2/3. There was much discussion about the fact that 12.3 says that the administrator may pay nil compensation, that it doesn't say they have to, they must, and that this somehow is acceptable. It is not acceptable, because what the may does is grant a power to the administrator to engage in an unlawful act, which is the payment of nil compensation, which we say is incomprehensible for the reasons that I illustrated earlier, which is that you can never pay an amount of nothing. It can never amount to compensation. It cannot be an amount. And so if it is forbidden by our constitutional framework, then you may not engage in that activity. So on that basis, the may, which grants this power, must be found to be unconstitutional. As we say, the Constitution is ultimately the supreme law. It is that document, when properly interpreted, tells us that compensation must be paid. As our friends from Spock pointed out yesterday, the rest of the Act makes it very clear that it is all about making payment of compensation under conditions of expropriation. That throughout the Act, the rest of the context of the legislation shows that amounts must be paid in money. We know that there is no such thing as a 0 rand note, that it is impossible to pay nothing. And so not only is the section anathema to the Constitution, but it is incoherent with the rest of the legislation. Those are my arguments on why nil can never be permissible, and my learned friend will then address the remainder of our arguments.
Thank you, Mr. Ramson.
Justice Saldana, members of the court, I'm mindful of the arguments that have been made over the last 2 days, and so I won't repeat any of those submissions. I do intend, for the assistance of the court, to address 3 topics. The first concerns jurisdiction, the second concerns the principles of international law, and the third concerns the rationality inquiry. Before I address each of those topics, let me flag what my conclusions in relation to those topics will be. In relation to jurisdiction, we deal with the principles applicable to this court's power when there is a transfer of matters. And here we will deal with a specific case that considers the power of this court. It is a case that none of the parties have relied on, and we submit it is a case that this court will find useful when it grapples with the jurisdiction issue arising from the AfriForum and Vaderland matters. The second relates to international law, and here I will not repeat the arguments made by Vaderland, but what I will do is demonstrate why the only sensible interpretation to Section 25(3) of the Constitution is that it precludes null compensation because international law says so. And importantly, I will demonstrate that any alternative interpretation will create discrimination between South Africans who own property in South Africa and foreign nationals who own property in South Africa. We submit that that point has not been made by any of the parties. And the third concerns rationality. In doing so, I will reframe the debate that this court has engaged in relation to Section 12(3) of the Expropriation Act. And I will do so to emphasize what 12(3) must be rationally connected with. We say that it must be rationally connected to 2 important things in Section 25(3) of the Constitution. The first is the distinction between a deprivation of property and an expropriation. and the second is the standard of just and equitable. And here what I'm going to emphasize is that the standard allows Parliament to determine factors relevant to the decision on compensation, but it does not allow Parliament to fix a number, any number, whether it be 0, 1, or 100. And the reason for this is because there is no purpose in telling an administrator when they will get to nothing, when they will get to 1, and when they will get to 100. Unless, of course, the intention is to change the standard from what is just and equitable to a standard of no or without compensation, or a standard of nominal or low compensation. And here we submit that that is not something that Section 25 of the Constitution permits. At the outset, let me say that we draw the Court's attention to the profound implications of this debate on 25.3, because the Constitution uses the standard of just and equitable throughout its text when it talks to the powers that are intended to be flexible, that are not intended to be fixed. It does so, for example, in relation to this Court's remedial powers under Section 172, 1B of the Constitution. Parliament's regulation of that power through statute can only be for the purpose of giving effect to the flexible and broad nature of the power, and to do otherwise renders the power meaningless. I begin with jurisdiction. When we filed our heads of argument on 15 July 2026, the Rule of Law Project said nothing about jurisdiction. It said nothing about jurisdiction because jurisdiction wasn't in contention at the time we filed our heads of argument. None of the respondents disputed the jurisdiction of the court to hear the AfriForum matter to which we, the RLP, were admitted as an amicus. But in the President's heads of argument, which was filed on 21 July 2026, he says, paragraph 9, the following: as the three challenges have been consolidated and all attack the constitutional validity of the Expropriation Act in this court, they are met by objections to jurisdiction. Until the court determines that it has jurisdiction, it may not determine any other matter in the case. Now, in the same paragraph, the President accepts that he did not raise jurisdiction in the pleadings. The President's argument appears to be that because the applications have been consolidated through the transfer, this court lacks jurisdiction. And if the court lacks jurisdiction in one of the applications, the DA application, for example, then it will lack jurisdiction in the other applications. The President provides no authority for this proposition, and we have looked, and we haven't been able to find any. But there is authority against the President on the proposition. I have provided my learned friends for the respondents the authority of de Villiers, which I beg leave to hand up on this point. Now, Justices, the case of de Villiers is a judgment from a few months ago, in May. It's a judgment of the Free State High Court, and what happened in this case was that there was a transfer from the Northern Cape Division of the High Court to the Free State Division of the High Court. And the basis for the transfer was, to put it mildly, unsatisfactory. The reason for the transfer was because the lawyers were located in Bloemfontein, but none of the other connecting factors of the case had any relevance to Bloemfontein. The cause of action arose elsewhere, and there were no connecting factors. I draw the Court's attention to 3 paragraphs of this judgment. The first is paragraph 9. The second is paragraph 21. And the third is paragraph 22. At paragraph 9, what the Court says is, the issue is whether this Court, as the transferee court, may revisit or refuse to give effect to a transfer already ordered in terms of Section 27(1). So what the court is doing is describing what this court is entitled to do if there was a wrong transfer. In my view, this court lacks authority to reconsider the correctness or validity of the transfer order. That does not preclude this court from making certain observations obiter regarding the implications of such transfers on a proper interpretation of Section 27. And the court goes on to discuss why courts should be more circumspect about transfers.
Sorry about that, Mr. Chairman. Currently, is the transfer being challenged?
No, it isn't.
So why are you addressing up to this?
Because it's an argument we understand the respondents will intend to raise, and we wish to assist.
Is the transfer being challenged?
It isn't.
It's not.
As we understand it, it
And the
isn't.
respondents challenged it.
As we understand it, they haven't.
You say it's just an argument that's been made.
Correct. And we wish to place this authority before the court.
Let's just get clarity. Respondents. Mr. Maneki?
We haven't challenged the transfer, nor have we argued that the court lacks jurisdiction because this was by way of transfer. What we say is the question of jurisdiction is an objective question. A court can raise it meromortu. It's been raised by Parliament, not because there was a transfer, but simply on the basis that the connecting factors for this court to exercise jurisdiction are absent. And we have said in our heads that
So is that the transfer to the Western Cape High Court?
there is, well, yes,
Wasn't there an order?
there was an order, yes.
Or was it ordered by agreement?
It was. There's no challenge to the transfer, so the court is correct. The only point we have raised in our heads is where an issue of jurisdiction, of the jurisdiction of this court is raised by Parliament, it is incumbent on the court to determine that issue before it enters the merits, having heard everything. And if it is satisfied that it has jurisdiction, then decides the merits. But if it doesn't have jurisdiction, to decline to decide the merits. That's all we've said.
The matter was transferred to this court by agreement.
Yes, there was consent.
What else is there to be said about the transfer?
There's nothing to be said other than what my understanding of the argument by Rule of Law Project is that even if Parliament might be correct that in absent the transfer, this court may not have the jurisdiction to decide the challenge to the Expropriation Act. Once there is a transfer under Section 27, and that is not challenged, the transfer itself vests this court with jurisdiction, and this court cannot decline to exercise jurisdiction. I think that's really the point of the case. So what the point, as I understand it, is to insulate the AfriForum challenge from any challenge on jurisdiction that Parliament raises. To say, even if Parliament might be correct in respect of the DA challenge and maybe the Fatherland challenge, the AfriForum challenge stands on a different footing because it came to this court in terms of Section 27 transfer. And on the authority of this judgment, as they read it, once the transfer is made and the transfer is not challenged, this court is vested with jurisdiction to at least deal with the AfriForum challenge. Yes, that's how I understand the argument.
Thank you. Ms. Hoffmeyer.
Thank you, Justice Saldana. My brief is only for Parliament in the DA case. You will have seen we have taken jurisdiction as an issue there. The only reason I would have dealt with any aspect in relation to transfer is if the DA sought to argue that somehow, because of the transfer of the AfriForum case to this division's jurisdiction in the DA case gets the benefit of that transfer. I didn't hear that argument to have been made, and if that is not to be the DA's position, Parliament's position in the DA case is that this court lacks jurisdiction. If the court is with us, the court will decline to enter the merits of the DA case, and it will be a separate matter what the court makes of its jurisdiction in relation to the AfriForum matter.
Thank you. Mr. McQueen.
Judges, in our papers, we have not squarely raised the issue of transfer, nor challenged it in our papers. We have not done.
Thank you. Mr. Dube.
We similarly have taken no position on the issue of jurisdiction, and on the basis that there's been a transfer, or on the basis that is contended by the Speaker.
Is there anybody else who wants to raise anything? Yes, Ms. Blair.
Thank you, Justices. Just to be clear and to avoid any misunderstanding, the DA did make the point in oral argument that the AfriForum matter had been transferred into this court. There's a Section 19 challenge in the AfriForum matter. The DA also challenges Section 19, and it was the court. Thank you.
It's fine, thank you.
Thanks.
Mr. Wenger.
I'm here on the sidelines. No, I said yesterday that we may wish to argue the jurisdiction, but only if he raises it. It has not been raised in our case. We fully agree with the argument that transfer alone gave us this court jurisdiction, because it was by agreement between AfriForum and the four respondents at the time. There were some added respondents later, and they said that they also not raising that.
Thank you, Mr. Wenger.
Justice.
Hold on, we didn't get to this one yet. Mr. Borster?
We agree with what Ms. Donald said.
Good, thank you.
Justice Saldana, the premise for my submission was indicated by Ms. Pillay to have been incorrect. I understand the DA's position to be that they get the benefit of the transfer for their jurisdictional woes. I will address the court on why we say as Parliament in the DA case that should not be so. But I'm prepared to do that in my main address in due course.
Good, thank you. So to proceed,
Justices, nobody challenged our jurisdiction. So if they all fall by their wayside, we're sneaking in on the side.
just in terms of transfer, Mr. Duplessis.
Pardon, Justice.
It's just in terms of transfer.
Yeah.
Thank you.
There's an imperative.
And the Emperor?
Honourable Justice, I just need to get clarity based on the directive that were given in terms of addressing the court. My understanding was that all applicants must address the court just before the respondent. And I'm one of the applicants, so I don't know whether I got to even though I'm an amicus.
The amicus, you're the amicus, you're not the applicant. That's what address is the amicus.
Yes. So my time is still coming.
Pardon?
My time is still coming later.
Your time's coming, yes.
Thank you.
Thank you. Is there any of the amicus who wants to say anything? Good. Thank you. Mr. Pereira, you may proceed.
As it
Now,
pleases
let
the court.
everybody else say.
As it pleases the court, Justice Saldana, I won't persist with the argument in relation to the de Villiers case. We simply point out that it was raised by us in response to paragraph 9 of the President's heads of argument. If we understood paragraph 9 incorrectly, where the President says, and I must read it again, that all three challenges have been consolidated and all attack the validity of the Expropriation Act, they are met by objections to jurisdiction. We respectfully submit that can't be correct. The transferred matters can't be met by an objection to jurisdiction, and the de Villiers case says so. Could I then turn to address the international law considerations? Now, Justice Saldana, in the debate with Mr. Duplessis, it was suggested that there's a grey area in international law and that there's a dissensus in international law regarding compensation. We submit that there is no dissensus, and we submit that there is no grey area. There is not a single authority by a regional or an international court that says that compensation may be null or that it may be nominal. Not one. Every single court that has considered the possibility of awarding a person nothing for expropriation has rejected it outright as a possibility. Mr. du Plessis relied on the decision of the SADC Tribunal. The court will find the decision of the SADC Tribunal in the Rule of Law Project's bundle of authorities. It is at page 162 of that bundle, where the SADC Tribunal says it is difficult for us to understand the rationale behind excluding compensation for such land, given the clear legal position in international law. Could I just emphasize the clear legal position in international law? It is the right of the applicants under international law to be paid, and the correlative duty of the respondent, that's the state, to pay for fair compensation. Moreover, the respondent cannot rely on its national law, its constitution. You cannot rely on the Expropriation Act to avoid an international obligation to pay compensation, as we have already indicated above. Now, this principle is well established as one of international law, but it is so well established that it even predates the existence of the International Court of Justice. Could I ask the court to turn to page 168 of our bundle of authorities, where the court will find the Chawza factory case of the Permanent Court of International Justice, that's the predecessor to the ICJ.
What page is it?
168. Now, for context, Justices, what happened in this case was that at the end of the First World War, and as a consequence of the Treaty of Versailles, a dispute arose between Poland and Germany because an area of Germany before the Treaty of Versailles, the Upper Silesia, was given to Poland as part of the treaty. Germany, its nationals, a German company, owned a nitrite factory in the Upper Silesia. And Poland argued that the effect of it acquiring that territory was that the factory, the nitrite factory, belonged to it. Germany disputed this. Germany said, no, that property belongs to our nationals, it belongs to our company, and that dispute went to the PCIJ. The court in the Chawza factory case established two principles of international law that form the bedrock of international law to this day in relation to both expropriation and compensation for wrongful acts. Every decision that considers a matter of expropriation almost invariably goes back to the 1928 decision of Chawza factory. The first proposition that the Chawza factory case establishes, the court will find at page 169 of our bundle, where the PCIJ says, this is under Roman 3, the second paragraph. The paragraphs aren't numbered, but it's the Roman 3, second paragraph that I'm reading from. It says, the action of Poland, which the court has judged to be contrary to the Geneva Convention, is not an expropriation. And here's why it's important that the court says it's not an expropriation. To render which lawful, only the payment of fair compensation would be wanting. So here the court establishes that time-old principle of international law, that where there is an act of expropriation, there must be compensation. If there is no compensation, you cannot describe this thing, this act, as an expropriation. The court then distinguishes expropriation from other things. It says it is a seizure of property. So when you don't compensate, it is a seizure of property rights and interests which could not be expropriated even against compensation, save under exceptional conditions fixed by Article 7. And then importantly, over the page, the court then describes what is the customary international law principle in relation to wrongful acts where outside of the expropriation regime. And the court finds that 171 of our bundle, it's the penultimate paragraph where the court says, the essential principle contained in the actual notion of an illegal act, a principle which seems to be established by international practice and in particular the decisions of arbitral tribunals, is that reparations must, as far as possible, wipe out all the consequences of the illegal act and re-establish a situation which would, in all probability, have existed if that act had not been committed. Now, could I pause here, Justices? What you see there is a description of something that's more akin to market value compensation. So where you commit an internationally wrongful act, you seize the property unlawfully, then international law says that there must be full reparations. But international law doesn't take that position necessarily in relation to expropriations. Because what international law requires for an expropriation, the court will find at 169, is only the payment of fair compensation would have been wanted. That is the principle of international law that Chawza Factory made clear, and it has been followed by the ICJ on several occasions. Gapsikova Nagimores in 1997, the Legrand decision between Germany and the United States, the armed activities case between the DRC and Uganda in 2012, and the Diallo case between Guinea and the DRC in 2012. Now we recognize that there is contention in international law between what's called the Hull formula, appropriate compensation, which is akin to market value compensation, and adequate compensation. But there is no dispute that there must be compensation, and that compensation must have a genuine value, what the authorities refer to as valeur réelle or valeur genuino.
What's the translation?
I practiced, Justice. So, any suggestion that international law countenances the idea of nil, nothing, is incorrect. There is a reason why none of the respondents, and not even the amici for the respondents, have been able to identify a single authority. It doesn't exist. Let me say what they would have to do to demonstrate that customary international law is on their side. They bear a burden under international law to prove that this is an accepted practice. We know that they bear that burden from at least 3 decisions of the ICJ. It's the asylum case, ICJ reports 1950, pages 276 to 277. The North Sea Continental Shelf case.
Sorry, is that the first case? Is it in your bundle?
It isn't in our bundle, but it is in our heads of argument, if I recall. Justice
So you said the asylum case?
The asylum case, pages 276 to 277. It's a 1950 decision. The North Sea Continental Shelf case, ICJ reports 1969, paragraph 77. And the right of passage over Indian territory, the dispute between Portugal and India, ICJ reports 1960, pages 39 to 43. What's this? So if the court goes to our authorities index, sorry, not our authorities index, the table of authorities which we attach to the heads.
Asylum case number 3. of the
That's,
international list.
that's right. And the North Sea is 11. The one case we didn't include is the dispute between Portugal and India, the right of passage over the Indian territory case. That's a 1960 decision.
Could you please give a full citation of that?
Yep, it's ICJ reports. 1960, 39 to 43.
Will you send us a copy of those decisions?
Exactly. Why is all of this significant? It's significant for the following reason. What 12.3 would allow is for a South African citizen to potentially have their property expropriated for nothing. But if a foreign national who has property in South Africa has 12.3 applied to them, they will always be entitled to compensation before an international tribunal. And in almost every instance, they will be entitled to something that's greater than just an equitable compensation. They would be entitled to market value compensation for the following reason. South Africa has nearly 50 bilateral investment treaties with a range of countries. Zimbabwe, Nigeria, the Czech Republic, Russia, Finland, Senegal, Sweden, Mauritius, China, Iran, Cuba, South Korea. All of these BITS agreements recognize that there must be compensation for expropriation. And almost all of them say that the compensation that must be provided would have to be market value compensation. For example, South Africa's BIT with China, which we reference in our heads of argument, says that if there is to be an expropriation of property owned by China in South Africa or a Chinese national in South Africa, then South Africa would have a duty to compensate market value. Now, even if it's the case that we are outside of a BIT, outside of a bilateral investment treaty, it would still be the case that countries are entitled to enforce compensation against South Africa for its nationals in international forums. That would be on the basis of the doctrine of diplomatic protection. We refer to this in our heads of argument. It's where a state lays claim for wrong on behalf of its nationals against another state. And we refer to the Barcelona traction case for that principle. So this court has an obligation.
What was the date of the BIT between South Africa and China?
I can't recall, Justice Saldana. I would be misleading you if I told you there was a date.
Yes, a claim for compensation by a foreign national would first have to proceed and have to exhaust local remedies.
Not necessarily, it depends on the bit. I mean, the way it usually works is...
Assuming it's not the bit. Assuming they're relying simply on international law.
No, yes.
Would they have to exhaust the remedies first in South Africa?
Yes, it depends on which court you would be going to. So, for example, if you were to go to the African Court of Human and People's Rights,
yes,
and a foreign state would assert a claim on behalf of, well, actually, let me say this. The African Court of Human and People's Rights recognizes that there may be claims brought against states that aren't state-to-state disputes. So national could bring a case, or NGO could bring a case even before the African Court of Human and People's Rights. There would be no obligation to exhaust an internal remedy if, for example, a foreign state brought a dispute against South Africa before the ICJ. I mean, that happened in the Diallo decision between Guinea and the DRC, where what happened was Mr. Diallo owned property in Guinea. That property was seized by the DRC, and Guinea brought its claim directly to the ICJ for that seizure and demanded compensation for the seizure.
Maybe it was an individual as opposed to a state.
Correct, yes. So if my property, which I don't own, was expropriated, I could go to the African Court of Human and People's Rights and lay claim there. They would ask me, do I have admissibility and jurisdiction, and that would require an exhaustion of a local remedy. Yes.
So you have to
Exhaust your local remedies.
exhaust a local remedy. And the local remedy, assuming the constitutional court, is to find nominal as opposed to market. How will the African Court of Human Rights deal with that?
I don't want to speculate, but what I can say is this. If this court goes to what was said in Campbell, could I actually ask the court to go to page 162 of our bundle? Because I think it might give you an answer, Justice Sultana. So the passage that I wish to draw the court's attention to is at 163. It's after the court has said that international requires compensation. Then what the court says, the SADC tribunal, my apologies, says is, moreover, the respondent cannot rely on its national law, its constitution, to avoid an international law obligation to pay compensation, as we have indicated above.
The market.
No,
What was the finding? Was it market or was it nominal? We're talking about no. Because that's where the debate is coming. Talking about in respect of market compensation.
I would not make a submission that it's market value compensation. And anyone who would suggest that international law is clear that all compensation must be market value compensation, in my respectful submission, would be incorrect. Mr. Oppenheimer tells me that the bid between China and South Africa was concluded in December 1997. So what we do is we simply point out to the court that you must favour an interpretation that is reasonable. We've given the court the authority that says that you interpret law in a way that avoids a discrimination. There would be a clear discrimination if 12.3 is kept alive. Rationality is my final topic.
So did you tell me what the discrimination is?
Well, you'd be privileging the amount of compensation that a foreign person gets.
Oh, sorry, I thought we were just making a general position.
No, they have greater benefits. Yeah. There's no equal treatment in law. The South African gets nothing, the foreign national gets market value.
Market?
Yes, under a bit. So, for example, China's bit with South Africa would require market value compensation for every expropriation. So I turn to my final chapter dealing with rationality. Justices, the respondents in this case have accepted that there cannot be an expropriation without compensation. So they draw a distinction. They say that you must distinguish between without compensation and null compensation. Of course, in both instances, the conclusion is the same. You get nothing. But they say that you must reason that the two things are different. And how they distinguish it is they suggest that the difference lies in process, not the outcome. So if you follow the 12-3 process, you get to null compensation, you do the exercise, and because you do the exercise, that's different from without compensation. This court would have to conclude that the process renders it rational. It takes it outside of the without compensation and creates a legitimate null compensation world. We respectfully submit that rationality requires there to be a connection with 25.3. And we submit that there is no connection with 25.3 for at least two reasons. The first is that it fails to distinguish between deprivations of property and the expropriation of property. I'm going to ask the court to turn to the Steinberg decision shortly. But the important point is this. We all accept, it's the law, it's even international law, that a deprivation of property may occur without any compensation. But where you expropriate, you require compensation. That the Constitutional Court explained in Harkson versus Lane. And I refer to the Steinberg decision, which quotes Harkson. It starts at page 74 of the Rule of Law's Bundle of Authorities. And the particular passage we rely on is paragraph 4, where the SCA, Justice, you tell me if I'm jumping ahead.
Paragraph, please.
Paragraph 4. It's at page 77. The SCA says, a fundamental distinction is drawn in section 25 between two kinds of taking, a deprivation and an expropriation. It is only in the case of expropriation that there is a constitutional requirement for compensation to be paid. The purpose of this distinction is to enable the state to regulate the use of property for the public good without fear of incurring liability to owners' rights affected in the course of such regulation. The essence of the distinction and the fact that it is well established in our law appears from Harkson, and it quotes Harkson, which I won't read. But that's the distinction. So if there is an instance where the state wishes to take for nothing, it is entitled to do so. It is entitled to deprive, but that deprivation must not be an expropriation. Because when it is an expropriation, compensation is required. Let's just look at the abandonment example, which Mr. Borgstrom mentioned yesterday. It may conceivably be the case that Parliament enacts a law that says where you've abandoned your property, that property falls to the state. Now, someone might bring a case to say, well, that's an arbitrary deprivation of property, but my sense is that case would not succeed because you've abandoned your rights in ownership. You say, I am no longer the owner. That's the whole point of abandonment. Mr. Borgstrom called it res nullius. It actually isn't res nullius. Res nullius is when a property is never owned. It's res derelicte. It's abandoned property for whom there is no present owner. So when it is the case that the state wishes to take in that kind of way, it is entitled by legislation, common law does it already, but it is entitled by legislation to deprive with nothing. If you build a facility that stores toxic waste inconsistent with safety regulations, there might be absolutely no problem for the state to say, I'm seizing and I'm giving you nothing. But that isn't an expropriation. That's a deprivation of property. So it fails on rationality in the first instance because it does not do what Section 25 commands, which is to draw the distinction between deprivations and expropriations. There's a second reason, and that's the last reason. And that is that 12.3 alters the just and equitable standard. Alters the just and equitable standard. When the Constitution tells courts, officials, functionaries, that they must do something in accordance with what justice and equity demands, it contemplates broad powers. You do everything necessary to achieve what is just and what is equitable. I'm not for a moment suggesting that Parliament can't regulate. It can determine factors. It can list 10 factors. But there is absolutely no purpose in the course of that regulation to fix a number, any number, 1, 100, 1,000. What would be the purpose of Parliament saying you may award compensation in the amount of 10 rand? What is achieved by telling the administrator that? What would be achieved if it were to say you may award compensation in an amount of infinity? There is no purpose. Certainly the respondents haven't identified one. The best answer comes from the President, where he says that it gives expression to 25. Of course, legislation doesn't give expression, it regulates in the first instance. And in the
They do it in terms of sub 8, section 25.
Sub? Pardon me, Justice Lockwood.
Section 25.8, which empowers them to pass legislation.
Could they...
Sub 8, could they pass legislation regulating nil compensation or not? Because that would be a form of deviation.
It's quite correct that that would be subject to a limitations analysis.
Yes.
But before you get to a limitations analysis, you ask, is the section rational? You don't get to limitations if there's no rational connection.
Yes, but we're not in section 36, we're in section 25.8. I'm asking you whether, in terms of what you're arguing now, they could do so in terms of sub 8.
You could enact a law, as 25.8 suggests, that would have to be disciplined by the limitations analysis, as 25.8 says. Of course.
And would it entitle them to pass a law that regulates nil compensation? What I'm asking.
If it's a rational law.
Rationality determined in accordance with.
Is there a connection between the empowering scheme, 25.3, and the law that you enacted?
So you're back at 25.3.
Correct. You start with asking, is the law rational? If there is no rationality, then you don't get to, that's the end of the inquiry. I can't remember the cases, but there are lots of clever people in this room who will tell us that.
Well, you've already told us Volkstrom was talking. I don't want to say nonsense. I'm sure someone in the next few hours will say you were talking.
I'm sure. I'm sure.
No nonsense, I guess.
Marshall. So the simple point is...
What is the question?
Pardon me,
What
John?
is the question? What does the state seek to achieve?
Yes, that's the critical question. The answer is without compensation. There is no purpose here other than to say that you may expropriate without compensation or for very little. That's the objective of this section. It's to take us away, pardon me, Justice Saldana, it's to take us away from what's just and equitable, which is always flexible, open-ended.
As the statement says, we have a public interest. That's what we want to achieve, land reform. And to achieve land reform, we can expropriate in very exceptional circumstances.
Justice
No, it's
Saldana.
not the end.
Yes.
Land reform is the end.
Yes, Justice Saldana.
This is one of the debates that they've raised in the papers.
I'm grateful for the question for this reason. That isn't a justification put up. I'm not suggesting that you can't raise it. But in order for that justification to be raised, it would require the parties to deal with it properly and fairly, because it might be disputed. In fact, I submitted it probably would be disputed.
Land reform would be disputed.
No, what would be disputed is whether this mechanism is a necessary mechanism to achieve the full objects of land reform. So if the state said...
Papers are replete with that.
I do not understand the respondents to suggest that there is a deficit in funds which requires the state to expropriate for nothing.
They say it's one of the mechanisms that will assist you to achieve land reform. And it's an objective that's in Section 25.
Yes. I understand that was an argument raised by, I know it's Mr. Bishop's client, the Association for Rural Advancement. But that's an amicus.
No, but have they not said that the purpose of all of this is for land reform in the context of Clause 3? They never said that.
No, that's different from saying that we don't have enough money to achieve proper land reform, and that's why we need nil compensation. Because that's a disputed fact. If the state says, I can't pay compensation because I don't have the money to pay the compensation, that might be a rationality reason put up. And that would invite the parties to respond to it, to say, well, maybe there is money, or look at this. But the funding issue hasn't been identified as a reason.
Mr. Padumasari, I've never understood them to say nil is the end. We simply want to achieve nil compensation.
I haven't understood the respondents to identify an objective behind nil compensation.
But you said that their argument is to achieve nil. Exercise is the process is to achieve nil. I've understood that to be, but I might be wrong. Might be there in the papers.
What I'm doing is making a submission that the effect of what 12.3 does is to say you can expropriate without compensation. It's to take it outside of the just and equitable standard by identifying a number. It alters what the Constitution requires, and it imposes a different standard without or for very little. And either of those things is not just and equitable. It's not what the standard that the Constitution prescribes.
They insisted that the controlling standard is just and equitable. There are their papers. That's what they've argued.
No, they certainly do.
And so, how do they take it out of the just and equitable standard?
Because they don't identify what it does. What does it do to fix an amount? Any amount. Let's take it out of zero. Let's assume you fix it at 10 rand. What does it do? What purpose would it be? What purpose would the legislation serve if it were to fix an amount? Remember, my case is that justice and equity may require the identification of factors, but we cannot understand why it requires the identification of an amount. And it is for the respondents to locate what work is the identification of an amount, any amount, doing.
Well, what we do know is that market value is not the amount per se. Could be after the exercise of the just and equitable exercise. So the market is not the end in all circumstances. How else do you then make the balancing? How do you achieve the balance between the interest of the affected person and the expropriated authority? Other than having to consider factually what Parliament or what the Constitution has told you, a number of factors from A to E in 25. Otherwise, you're back to market.
No. You do what the Constitution requires you to do. You put all the facts in a basket.
Yes.
You weigh them up. And you say, all things considered, this property is valued
X.
at X.
At X. And notionally, X can be less than market.
Oh, of course. There's no dispute about that, I would submit.
You're saying why tell us, why start with a number when
What?
you're being asked in terms of the Constitution to determine a number, an amount? That's what you tell.
That's correct. What do you do? What objective are you fulfilling? What does this do such that it is rationally connected to the justice and equity standard? Why is there a connection, a rational connection, a good reason between fixing a number and determining what justice and equity
And you
requires?
say none of the state respondents told us why.
Correct.
Except they said land reform, public interest.
You say they said it in generalized.
Okay. Let me take a step back, Justice Madonna. So let's assume the respondents say that we want to achieve land reform and therefore we need null compensation. Why? The conceivable answer would be because we don't have money to pay compensation that's greater than null.
Why do you keep focusing on money?
Because it requires compensation, payment for compensation, Justice Lockwood.
I'm asking why they must say we don't have funding in order to trigger sub 8, or in order to say in order to embark on land reform. I'm not being facetious.
No, I'm not sure I understand the question. Yes, so what I'm doing is this. I'm saying, if it's the case that, as Justice Aldana put it to me, the state says the rationality objective is land reform. That's the conclusion. Then the question is, how does null compensation achieve land reform? Now, the respondents don't tell us. Null compensation is necessary to achieve land reform for the following reasons. I discern that one of those reasons is that we don't have money to pay you anything greater than zero. All I'm suggesting...
But they can't say that. You see, because they don't say every land reform expropriation must be null. So it can't simply be because we don't have money to achieve land reform. Because they can't, and they're not asking for null in every land reform expropriation. They're saying in certain circumstances, exceptional circumstances, and they list it, null may be what the outcome is. That's what they say.
Justice Aldana, maybe I'm very, very slow, but what I don't appreciate in that analysis is what work is it doing for achieving land reform in the identification of any of those factors, firstly, and why is the payment of nil necessary to achieve land reform? That the respondents haven't given us a connection on.
Okay, let me not debate this further, let them debate with you, but it's not a question of using slow. It's simply that we've understood that the animating provisions in sections 12.3 is land reform. That's what it says. And that's what they say is what we want to achieve. But we don't use null, we don't expect null in every expropriation that we will seek under 12.3.
Look, it may be that my argument is wrong, but what I would have to be satisfied of, or what I would like to know, is how does it achieve land reform in any instance, in any of the particularized instances?
No.
What does it do to achieve land reform?
It's one of the many factors that the state will take into account in its budgeting.
Well,
Why not?
yes.
Was it you, someone raised an argument that there's no evidence of a link between nil compensation and land reform?
One of the other parties raised it. I can't remember which party.
It wasn't you.
But you see, Justice Saldanha, I think you're, with respect, correct. The obvious reason is there isn't money. There isn't money. That's the obvious reason. And if that is the case, then it's for the respondents to put up that evidence, and it's for the applicants to say that's not correct.
Why would you need just an equity and a balancing of interest to be a controlling mechanism if it's simply we don't have money? Because then you don't need to go through this exercise. The state simply confiscates on the basis that we don't have money.
Wait.
We needn't go through this entire elaborate process of just an equity and a balancing exercise if it's simply we don't have money.
Well, that would turn on whether the state's policy amounts to an arbitrary deprivation.
Precisely, and that's not what the state has said. And it simply can't be we don't have money.
Yeah, that's a bit too narrow. Not a bit, quite narrow.
But again, this isn't for me. This is for the respondents. I'm responding to what justifications have been put up. And I'm saying, my client says, that for you to identify a number, any number, doesn't serve a rational purpose unless what you're trying to do is to say I can expropriate without compensation. The respondents tell us that they cannot do. They accept, the respondents accept that they cannot expropriate without compensation. I understand that it's tea, so this is the end of my submissions. I just wish to say something on remedy. If we are correct in any of our arguments, then the remedy is to strike down 12.3. Prince 3 makes it clear that this court simply strikes down Prince 12.3. It doesn't do anything more than that. The parties have cited it. It's 2018, Volume 6, SA 393, Constitutional Court, and it's paragraph 2, where Justice Zondo says, it is neither necessary nor competent for a High Court to suspend an order of constitutional invalidity that relates to a statutory provision or an Act of Parliament. When it grants such an order of constitutional invalidity, it is unnecessary because 172(2) of the Constitution requires the Constitutional Court to confer. So you don't do anything more than a simple declarator. Those are the submissions for the Rule of Law project.
So who do we start with after the tea?
I think it's me.
The Emperor.
Not the Emperor. I'm not appealing for any Emperor, not this one or the other. But I think I'll start unless, as we discussed yesterday, unless the court has anything to discuss with Mr. Katz, I'm starting.
We received a document this morning.
Yes.
We don't know what the status of it is. At some stage it will have to be dealt with.
At some stage.
And we had lengthy debate yesterday about it, and we're not going to revisit that debate.
Yes, I accept. I'll be standing here after tea.
Good, thank you.
Now, just apologise on behalf of my junior secretary. The document that, now apologise, what happened to the document that you received? The document has an affidavit on the top, and underneath the affidavit is a notice of application. So you might not have seen the notice of application.
No, we saw that. We were particularly mindful of how does an affidavit be served on us, and at the bottom of it is the notice of
I'm apologising.
We're not going to have a debate with you about that, Mr. Casey.
No,
Not now, maybe later.
Whenever.
Ms. Hoffman will deal with you on that.
Thank you.
It's tea time, and we'll come back shortly. Thank you.
the argument that was presented orally yesterday departed somewhat from the pleaded case by IR Legal on 12.2e. Then I'll deal with the issue of remedy in respect of section 19.2, 3 and 4. And I will submit, we've had the submissions based on Prince 3, but I will refer the court to a judgment of the full court in this court handed down in March this year in the challenge to the VAT Act, where this court granted a suspension remedy and not only a declarator. So at best there is lack of clarity about that from this division. Then I'll deal with the challenge to section 19.8. And lastly, I'll deal with the publication issue concerning the president, which we submit is really a make-weight challenge. Then I'll address conclusion and remedy at the end. I will not address challenges which are raised in the papers but which our learned friends for the applicants and the amici have not addressed in oral submissions. We stand by our written submissions in respect of those challenges. And on the question of jurisdiction, we are allowing ourselves with the submissions that our learned friend Ms. Hofmeyer is going to make. And we preface this with the submission that although the President does not raise the issue of jurisdiction in his answering affidavit, the question of the competence of the court to determine the merits of the challenges is an objective question which this court would have been entitled to raise mero motu. And once it's raised, the court is duty-bound to determine it before it enters the merits. And we refer specifically to the President's answering affidavit in the AfriForum case, which the court will find at 004-51. I'm not asking the court to go there. At paragraph 180. There you will see that the President recorded that the AfriForum application was transferred to this court and said, which also has jurisdiction. So he assumed the court has jurisdiction. That's at best an assumption of law or admission of law, which doesn't bind the court if it is wrong. If our learned friend Ms. Hofmeyer is able to demonstrate that was a wrongly made submission, the court is not bound by that. Courts have said it many times that the court must uphold the rule of law, and the errors made by parties do not bind the court. But the reason why jurisdiction is a matter the court must decide is because if it didn't decide it and it didn't have jurisdiction but determined the merits, that determination would be a nullity and there would be nothing to refer to the Constitutional Court for confirmation. So then I move to the first topic, which is the challenge to Section 12.3. But before I do that, I just want to clarify one aspect which the court has expressed great interest in, but with respect there hasn't been clarity in the way in which it has been presented to the court. And that is the role and the place of international law and foreign law in this challenge. The first point to make is under Section 39.2, it is correct that when the court interprets the Constitution, the provisions of the Bill of Rights, 39.1b, it must consider international law. Specifically governs the place of international law in our jurisprudence. And it's important that we highlight that because sometimes the case has been presented as though you are dealing with an international dispute to which international law applies directly. But you're not. You are dealing with a domestic dispute, and so you start with the Constitution and domestic law. What Section 232 of the Constitution says is, customary international law is law in the Republic unless it is inconsistent with the Constitution or an Act of Parliament. So, I'm going to, in my submission, show you that Section 25 is consistent with customary international law. And so, this case involves the interpretation of that section. It's not a question of whether there may be inconsistencies between the section and international law. The second point that's of relevance is, in our submissions on 12.3, we are going to say to the court, firstly, that section doesn't breach section 25, but to the extent that there is a limitation of the right to just an equitable remedy in section 12.3, if you find that on the arguments of our learned friends, then there is a breach of section 25, and we will submit that that breach is justifiable under section 36 of the Constitution, is a justifiable limitation. Now, the application of section 36 cannot be trumped by customary international law. Customary international law, because where section 36 says no right in the Bill of Rights is absolute, it may be limited by a law of general application, provided you can meet the standard in section 36, then any principle in customary international law which is contrary to that would be inconsistent with the Constitution and not applicable under section 232 of the Constitution. So you will only look at section 36 and forget about international law when you're dealing with limitation analysis. Then you had a lot of arguments about bilateral investment treaties by our learned friend, Ms. For the Rule of Law project. I always get my tongue tied when I try to say his name, and I don't want to say it wrongly. He's been a colleague, and I've appeared with him many times, and I've pronounced his name correctly, but I don't have it in front of me. I don't want to pronounce it wrong. But he's a very, very good counsel, and it's possible that in his arguments the court believes that the BIT treaties are relevant to interpreting, determining whether section 12.3 is valid or not. Now, the treaties are governed by section 231 of the Constitution. It says who negotiates international agreements is the responsibility of the national executive, and an international agreement binds the Republic only after it has been approved by resolution in both the National Assembly and the Council of Provinces, unless is one referred to in 3. That would be agreement of a technical, administrative, or executive nature binds the Republic once it only needs tabling in the NCOP. And any international agreement becomes law in the Republic when it is enacted into law by national legislation. But a self-executing provision of an agreement that has been approved by Parliament is law in the Republic unless it is inconsistent with the Constitution or an Act of Parliament. So the same thing. But the point about the bilateral treaties is that if it's an investment treaty, and in that treaty, the standard applicable is that compensation for expropriation is market value. That is the standard that will bind the Republic. And when there's a dispute regarding bilateral treaties, international law regulates. And when international law regulates, you can't rely on your domestic law, which allows you to expropriate for nil compensation. So it's important just to bear that in mind as far as the place of international law in this debate. But now, I address my submissions to why we say there's no breach of Section 25.3. And we do so by first highlighting 5 fundamental points of departure, which we submit the court must evaluate, assess the constitutionality of Section 12.3 against. The first point is that Section 25.2b of the Constitution must be read in the context of Section 25 as a whole and not in isolation. You'll have seen our learned friends, for some of the parties, read Section 25.2b and then went straight to the dictionary to find a definition of compensation and said compensation means kitching, and so you can't have compensation that may be nil, consistent with the Constitution. So we submit that that's a wrong approach. One must read it in the context of 25 as a whole in the Constitution, and when it is read properly in that way, it is clear that in relation to expropriation, the Constitution only guarantees the right to just and equitable compensation, and not merely compensation per se, as the Rule of Law Project would like us to believe. So it's only just an equitable compensation. It's not recompense for what you lost. Sometimes it may be, sometimes it may be less, because it is just an equitable compensation. And that standard was deliberately chosen in the Constitution. And you will see in the certification judgment, which we haven't referred to, it is 1996, Volume 4, SA 744, Constitutional Court. At paragraph 73, the Constitutional Court dealt with whether the Section 25 was consistent with the principles agreed. And the court has this to say at paragraph 73. The second objection was that the provisions governing expropriation, and in particular for the payment of compensation, also fall short of what is universally accepted as contemplated by CP 2, that's Constitutional Principle 2. The argument was that the NT should stipulate that the compensation should be calculated on the basis of market value, and that expropriation should take place only where the use to which the expropriated land would be put is in the interest of a broad section of the public. The objectors also argued that expropriation for purposes of land, water, or related reform contemplated by NT 25 Section 8, Section 25.8 now, fell short of the universally accepted understanding of the right to property. Once again, and for the reasons given in the previous paragraph, we cannot accept these arguments. An examination of international conventions and foreign constitutions suggests that a wide range of criteria for expropriation and the payment of compensation exists. Often the criteria for determining the amount of compensation are not mentioned in the Constitution at all. Where the nature of the compensation is mentioned, a variety of adjectives is used, including fair, adequate, full, adequate, equitable and appropriate, and just. Another approach adopted is to provide that the amount of compensation should seek to obtain an equitable balance between the public interest and the interests of those affected. Some constitutions too prescribe that the compensation must be prompt or made prior to the expropriation. Similarly, there is no consistency with regard to the criteria for expropriation itself. The approach taken in NT 25 cannot be said to flight any universally accepted approach to the question. So that was the point I was making at the outset, that the standard adopted by our Constitution is consistent with customary international law. But what it means is, so we accept expropriation is subject to compensation, but the Constitution gives content to what it means by that. It says it is just an equitable compensation when all relevant circumstances are taken into account. And compensation per se, as is argued, would be a guarantee to recover loss, which is not what the Constitution adopts. It adopts a flexible standard which may result in an amount which is far less than the loss suffered as a result of expropriation. That was the first point I'm making, that we are concerned with just an equitable compensation and not just compensation per se. The second point we make is that Section 25.3 of the Constitution contains a non-exhaustive and non-hierarchical list of relevant circumstances or factors to determine just and equitable compensation. There is no suggestion in the case law or in any of the applicants that the listed factors are hierarchical nor privileged merely because they are listed. You will recall that they say in argument 12.3 privileges certain circumstances because it names them. But they're driven to accept that Section 25.3 employs the same structure of mentioning non-exhaustive lists in a non-hierarchical fashion. That is not to say that the non-listed factors enjoy less weight when considered in the context, in the weighing up. Non-listed relevant factors enjoy similar consideration as those that are listed. That's the second point we make. The third point we make is that Section 12.3 of the Expropriation Act does not depart from the constitutional standard of just and equitable. Because when you read it, it's clear that it permits nil compensation only, and we underline only where it may be just and equitable in the light of all relevant circumstances, which include the listed and unlisted relevant circumstances, in much the same way that Section 25(3) does. So you had a lot of our learned friends telling you about different examples. You had an example of a property owner who has 10 farms. They are agricultural farms, not being used productively, immigrates to Australia and keeps 2 horses maybe at each farm, just to bypass the provisions of Section 12(3). Now, when an expropriating authority considers what just and equitable compensation must be granted, that factor will be taken into account, that there is some use. He comes and rides horses from time to time. That will be taken in the wash, and the balancing exercise will be conducted to determine whether what may be just and equitable. Sometimes those unlisted factors may point against nil compensation, and they're taken into account and they are weighed. So that's the third point we make about Section 12(3), that it is faithful to the constitutional standard or constitutional norm of just and equitable and regard to all relevant circumstances. It doesn't depart from it. And that's what matters. It's not the number that is mentioned, it is the constitutional standard, because that is what informs what compensation means and is consistent with international standards. The fourth point we make is, as is the case with Section 25(3), the listing of circumstances in Section 12(3) does not privilege the listed circumstances in contradistinction to relevant but unlisted circumstances. Once a factor is identified as relevant but unlisted, it enjoys similar consideration, and it is put in the weighing up that the section itself requires. The fifth point we make is, and we say it's very important for purposes of the challenges, is that when Section 12(3) of the Expropriation Act is interpreted in the scheme of the Act as a whole, and this is where we say with respect, and we respect our learned friends and the submissions they make, is that when you look at it in the scheme of the Act as a whole, it is clear that it does not authorize an expropriating authority or a court to start the inquiry for determining just and equitable compensation by simply asking whether any of the listed circumstances exist, and from there to automatically offer or approve nil compensation, offer in the case of an expropriating authority and approve in the case of a court. I will demonstrate, looking at the scheme of the Act, that what it requires is the same investigation that would take place even if Section 12(3) was not there. But what 12(3) does is simply to provide guidance, and we'll come to that and say it does perform a function in relation to public interest expropriations. So we submit against those 5 points of departure that 2 submissions are available to the respondents. The first is that Section 12(3) does not breach Section 25 of the Constitution, in that it does not limit the right to just and equitable compensation guaranteed in Section 25, as it requires that nil compensation may only be the result if it is just and equitable in the light of all relevant circumstances, which is the constitutional standard. If we are wrong in that, and the court finds that the mere fact that it opens the door for the possibility of nil compensation expressly, that in that way it limits the right to just and equitable compensation guaranteed in Section 25, then we submit that that limitation is justifiable under Section 36 of the Constitution. And we will demonstrate to the court that the Constitutional Court itself has envisaged that expropriation without compensation may be justifiable under Section 36. And the Land Claims Court has already upheld a limitation where an act, the Extension of Security of Tenures Act, ESTA, allowed for expropriation without compensation. It does not mention any compensation, and the court said that was justifiable under Section 36. Our learned friend maybe for AfriForum, I don't recall, or someone else said that court was dealing with deprivation and not expropriation. It was dealing with expropriation, and we'll refer the court to the judgment in our bundle of authorities, which we'll hand up when I get to the right place. So I promised my protected time is gone. Opportune time. I was going to take the court now to our supplementary heads because that is where we deal fully with the scheme of the Act to show that 12.3 does not depart from the constitutional standard. And I think it's important. It's maybe a tedious exercise, but it is a very important exercise because so far, and we submit with respect, the argument launched into 12.3 without reminding the court of how it must approach the challenge to 12.3 in a systematic manner, which the Constitutional Court has emphasized. We've all referred to the Chisuse judgment of the Constitutional Court, which deals with interpretation.
I was going to ask,
Yes.
that you, just on the 5 points that you've raised,
Yes,
before that you finished the 5 points. And then
I did finish the 5 points. Yes.
And then, perhaps you want to address us on what is understood by just and equitable.
Yes.
And what is an equitable balance? These are almost the mystic words that are used in all of the incantations around 12.3. And
Yes.
also 25.
Yes.
So, what does the president say is just
Yes.
and equitable?
So, and I will reference the cases that have dealt with this in the Constitutional Court, starting with the FNB case, Dutoy, Hafaji, and then the NAD case, that's the SCA. That what the Constitution is involved with here is to reverse the gross injustices of the past. So there has been land dispossession, has led to lack of housing, trampling on the dignity of the majority of South Africans, and the Constitution says we must reverse that. But in doing that, we're not going to negate property rights completely. We're not going to negate property rights. Proceed as if there are no rights to property. And as I referred to the Section 73 of the Constitution, instead of asserting a positive right to property, we put the right in the negative fashion, that you cannot be expropriated without compensation or deprived of property arbitrarily outside the law of general application. So that's so on the one hand, you must transform that there are rights on the other side. But what the cases says, property rights are not supreme in our Constitution. Property rights are not absolute. And that's why you have Section 25. So what you need to consider is what that the right to property must yield to societal considerations, meaning land reform, other public purposes, and the like. And the amount of compensation must take factors that are relevant to the societal consideration on the one hand, and the interests of the private individual on the other. And you must strike a balance. Now, so you could notionally get a property which was taken forcefully, unlawfully, and in which the state has invested money, and where the existing market value is accounted for purely or mainly by state investment. That's one side. On the other side, you might have a private owner who spent millions of rands to acquire property in the market and paid a big amount of money and has improved the property and the like. The balance will differ from case to case. In the one case, the extreme case I've given, it may be that there is no compensation to be given. It's nil or is nominal, because the property, because the section refers to the history of acquisition of property, the history of use and the like, and investment by state in the asset. So where the history of the acquisition of the property, and that's section 25(3)(b, is one of conquests and taking, for instance. And I'm positing an example because we are looking at a statute challenged in the abstract. You don't have facts. So you must look at it and say, on any interpretation, this statute is facially unconstitutional. So you have 25(3)(b) that says the history of the acquisition and the use of the property. C says the market value, and D is the extent of direct investment and subsidy in the acquisition and beneficial and capital improvement of the property. Let's posit a case in which the history of acquisition is conquest or illegal taking, and the market value is accounted for fully by the extent of direct state investment in D. The balancing exercise might yield a very, very small number or no number. But on the other scale, you may have a different situation where there has been acquisition on the market with investment, and you acknowledge that, and the value might be high. So what section 25(3) does is to leave it to this sense of justice of a court, having determined as a matter of fact each of these factors under 25(3), which may or may not exist in each case. What are the facts on current use of the property? What are the facts on the history of acquisition? What are the facts on market value and the like? Once you've established those facts, then you enter an evaluative exercise as to what the balance must yield. And that is a value judgment that is left to the court's sense of justice and equity. There will be guidance from previous judgments, but ultimately it is a value judgment that the court makes, given facts. So it's not a discretionary, as NAD, Justice Unterholter pointed out in NAD, the evaluation in section 25(3) is not a discretionary exercise. It's not a judge saying, well, I have true discretion. I have 5 alternatives. I can give 10 rand, 20 rand, 50 rand, and I can pick and choose. You have to find, as a matter of fact, the existence or non-existence of these facts, and then in the evaluation, judge what they tell you about where the balance should be. And it is in that context where we say, looking at 25(3) itself, without 12(3), there is a possibility that a combination of factors, they may be exceptional, as AfriForum and Vaderland, and I think our learned friend Mr. Bostrom, quite rightly, is criticized by the others because they saw what he said in written argument and like that, but in the cold phase of argument, he, as counsel does, he adjusted his argument in the light of looking at what everybody has said and what, on reflection, the statute indicates. That you could have a number which is 0.
That was in his heads of argument.
Yes. Oh, it was.
It was.
I misread it.
129.
I did apologize to him. I misread another. I take the correction, and I accept fully. But so our 3.
There's the administrator sitting in his office.
Yes.
And he seems they should do all of this investigation. Market value, there's researchers who go and do issue of historical dispossession. They will look at what the possible purpose of the land would be for. So he sits with this. Then the administrator, layperson, has to use this legal concept of just and equitable. Now, for most lawyers, and I must include myself, when it comes to the notion of what is justice, it's an extremely complex concept. And as much as we can read and debate, and one author tells us this is the idea of justice, and the other author will tell us this is what justice means. It is one of the most difficult concepts for any legal practitioner, let alone the judge.
Yes.
Imagine the layperson is now going to be applying this notion of just. Let's just start with just. I assume it's derivative of the word justice. So let us try to understand, what are we saying to the administrator? What do you have to evaluate? What are the tools that you use? And what assistance do you have in making this determination of just? And we'll talk about equity just now, because I suspect equity might be a little more easier, because in the Bruce translation it might be ordinary people, just be fairness. People must be treated fairly. Just?
It is correct that it is a complex standard for judges and for laypersons. It is complex whether one is looking at it under Section 25 or is looking at it under Section 12.3. It remains complex. But what the Act does in relation to expropriating authorities is it tells them what process they must follow. Firstly, that they must gather all relevant circumstances. That's Section 5.1. It says, I'm building to the answer. So it says you must, an expropriating authority must investigate all relevant circumstances, which include in 5.1 the suitability of the property for the required purpose, public interest or public purpose, the existence of registered and unregistered rights in the property, and facts relevant to calculating an amount of compensation that accords with Section 12. In other words, you haven't left out circumstances and just started with nil compensation. And you formulate an offer of just and equitable compensation, which you will then offer for consideration. Now, what we submit that obligation entails for an expropriating authorities, at the very least, what you're going to offer must be justified by the facts that you've gathered. So you must have looked at all the relevant circumstances, including those that are not listed, that you may be aware of. You've looked at all of them, and you can say, when you say 20 rand, you say because the market value is X, and we've looked at the investment of the state and the like. So it's justifiable by facts. So there is a body of facts. And then the fixation of the amount can be arbitrary, in that there must be a reason for that, for fixing the amount. As the court told us I think it's in Scalabrine, Justice Wallace says, an arbitrary decision is one which is for a reason. But if it's not for a reason, it's arbitrary, capricious, irrational. So there must be a reason why you arrive at a number. And that reason must relate to the findings of fact that you have made in your gathering of facts. Justice is that determination. And then you make a value judgment. But it mustn't be arbitrary, it must be reasoned at least. And we know that administrators are not held to the same standards as judges, where you must give reasons for every... The nature of the reasons and the way you write judgments would be different from somebody giving reasons for an administrative action. But at the very least, a PAJA requires that there must be adequate reasons. I must be able to know, as a property owner, why you did not give me market value, for instance, or why you gave me nil compensation. I must know from the facts and the reasons that you've given. That same standard is the same standard that applies to the court. In NAD, the High Court had made the mistake of believing that Section 25.3 gives the court a discretion, is a true discretion where you have 5 alternatives and you can choose from any of them. And the SCA reminded the court that that is not correct. Section 25.3 requires findings of fact. Those listed circumstances are factual issues. They must be determined on the facts. And when you take your value judgment, it must be based on those proven facts. And administrators will differ. Even if you gave them exactly the same case, as does judges, the standard of interference is the standard we all know under Pacha and legality, either reasonableness or rationality under legality, and for judges, correctness. But if it's in a range of reasonable outcomes, it will be sustainable. So there are extremes here. There is the administrator who's not going to do its work. He's going to pick up and say, 12.3 says I can give nil. Let me see, C is here. Here is nil. That administrator will be acting unlawfully because that's not what the Act says the administrator must do. And all administrators are public functionaries, they're organs of state. They function within constitutional constraints. And those constraints are, they must not act outside their powers, they must not act in breach of rights, and they must act rationally if it's legality or reasonably if it's Pacha. And it's not idle because when they don't act in that way, then the property owner has a remedy of judicial review. Not only that, the property owner in fact has a referral to court under section 19.2 for a court of first instance to say that determination of compensation was not just and equitable because firstly you didn't act properly or it was not justified by the facts. So as the court said yesterday, I think to one of our learned friends, is you are here to decide difficult cases. Even the administrators are required to take the first decision, which is a difficult decision, and they must do so faithful to the Constitution, constitutional constraints, and when they don't, the law provides a remedy to those who are aggrieved. So
just to do it on the bite size.
Yes.
So you dealt with just. So it has to be justifiable, taking into having considered all the relevant circumstances.
Yes.
You must be able to point to anybody who says, how do you justify this decision? And you will point to a number of factors. Is there any other considerations that you take in terms of just? Whether the person has a sense of justice or whether the person doesn't have this. Because when administrators are appointed, their predilections towards justice is not evaluated. They might be the most nastiest of people, but who can do their job pretty well.
Yes. No, that would be a subjective standard because when you are evaluating whether the outcome is just, the court is concerned with an objective evaluation. Whether you are sitting there and yourself own 5 farms and therefore might not like nil compensation would be relevant from the equation. You are just looking at the legal standard and saying, is it met on the objective facts?
Then we deal with just and equitable. So
yes.
Equity, does that mean fairness?
You'll have seen in that paragraph 73 from the certification judgment that it draws a distinction between jurisdictions which choose fair and jurisdictions which choose just and equitable, jurisdictions which say nothing in the Constitution, and the courts develop the standard through jurisprudence. I would suggest that fairness and equity are probably closely related, but they're probably not the same thing because they're cousins, but I think equity would also take into account our historical context because you're looking at the interests of the private individual and the societal interests, and you're trying to correct and acknowledge wrong. But that might already be taken out into some of the factors. But the courts do emphasize that the historical context informs our interpretation and application of Section 25.3. Because unlike the history that AfriForum highlighted, they accept the historical context is relevant, but they highlight the attempt to change the Constitution as the historical context. there is a far bigger historical context, which is the dispossession over many, many, many years, and the dignity that and it's paragraphs 17 and 18 of NAD, I'm told, that yeah, but I think that goes back to what I was saying earlier. So in 17, this SCA says in NAD judgment, in our bundle of authorities, which we put in the front there, maybe handed up, it will be, but I don't propose to take the quote there. It starts from page 1149. So I might refer to some of the judgments when I get to other points.
Which one are you? One or two?
Is the second one. The second one starts from 790. And I mustn't forget the question that was raised. Oh, it was about equity. I must come back to that. But I just want to anchor what I just submitted earlier about the difficulty of the exercise by reference to what the SEA says. Page 1157.
1157.
Yes. And the court here is dealing with whether it's a discretion. And paragraph 16 says, first, section 25.3 is not cast as a regime of discretion. It specifies that compensation must be just and equitable. Second, 25.3 requires that a court has regard to circumstances that may be relevant, including an enumerated list of circumstances. These circumstances are matters of fact that a court where relevant must determine. They are not discretionary considerations. While findings of fact may give rise to different conclusions, these differences are not matters of discretion, but differences as to what findings the evidence supports. And this is an objective inquiry, not a discretionary exercise of power. Then 17, third, no doubt the equitable balance demanded by section 25.3 may in some cases be difficult to determine. But a matter that is difficult to adjudicate is not to be equated with a discretionary power characterized as a true discretion. The balancing of interests may give rise to different views as to how the correct balance is to be struck. So too how the relevant circumstances referenced in section 25.3 provide reasons for deciding what compensation is just and equitable may also require judgments that are difficult to make and may be contested. The concept of just and equitable references overarching legal values. Even in the domain of compensation for the expropriation of property, these values engage much complexity of history, distributive justice, and constitutionally sanctioned recompense. It is tempting in the face of this complexity to retreat into the protective embrace of discretion that confers both freedom and inoculation from intrusive review. It just restates what I was saying earlier, that these are matters of fact. But so going back to equitable, so you're looking at an equitable balance. So there is a scale which posits societal interest on the one hand and the private interest on the other. And the societal interest would include our history of dispossession. And so you try to strike a balance. And those factors are there to try to allow you to measure that. Because you see some of them belong strongly in the societal considerations, others belong in the basket of the property owner. Market value sits strongly in his bucket or her bucket or their bucket, whereas the other will sit on the other way, and you are trying to weigh them. And the trade-off is the difficult part, but that trade-off cannot be made arbitrarily by simply going to 12.3 and saying, because a circumstance exists, I can give nil compensation.
But the historical circumstance will not operate or will not there in every matter
Yes.
the administrator deals with.
Yeah, that's
So if there's property that was acquired in 2002,
yes.
there may not be this history of dispossession to the property.
Quite. There might be, Yes, just quite correct. And that's why the Constitutional Court has emphasized repeatedly that not all the circumstances will apply in each case. Some will be applicable, some may not be applicable. But the way the trade-off was achieved in the negotiations was we want transformation, but we don't want to take, and we're going to protect property rights in a negative fashion, and the courts will do the balance, and they will develop jurisprudence which will guide these functionaries. They will look to the court on how, for instance, 12.3 fits into the scheme once the Act becomes law. You'll hear cases and you'll develop the jurisprudence, and the functionaries will apply it. There's a point about, there was a suggestion almost functionaries are incapable of performing this function. But we forget that unlike courts, there are also certain expertise that the functionaries have which courts don't have. They are capable of investigating a wider spectrum of facts, understand them given their specific expertise in particular areas like valuation of land and so on, which may be an advantage a court doesn't enjoy when it sits as a court of first instance, and that's why a court will be assisted by experts. So it is not correct to move from the premise that functionaries don't know what they're doing. And that's why in Batu Star, the Constitutional Court sounded a caution about deference, that courts must not assume superior wisdom to the functionaries and simply take their decisions and make the decisions themselves afresh. They must look at the decision made and assess it for reasonableness and rationality. That doesn't mean you retake the decision. It means you assess whether it falls within the proper bound. That's a recognition that functionaries bring a specific skill that the court may not have. You may have, I might be sitting tomorrow as a new judge on this bench, and a Director General who's been a Director General for the past 20 years dealing with expropriations may have made the initial decision. If I assume simply because I'm sitting as a judge, I know better, that is a mistake that Batu Star cautions against. And so it's wrong to assume, to proceed from this these people don't know anything. They're going to be confused when they are faced with 12.3. Well, they must be confused when they're faced with 25.3. Because it says it does exactly the same. It performs the function in the same structure and scheme.
So the question raised yesterday and this morning, so the function is, well, what's the purpose of this?
Yes.
What's the purpose of these factors that you put before?
Yes. Everybody here, and you will see, when they challenge certain sections of the Expropriation Act, they say a power is given without guidance. This allows for abuse and arbitrary action. The statute provides guidance in 12.3. They say, well, that guidance performs no function.
What's the purpose you seek to achieve?
The purpose of 12.3 is to advance expropriation in the public interest, which is land reform.
It's just also, you heard the debate this morning.
Yes.
And so, land reform, you can achieve it.
Yes.
And you seek, in certain circumstances, that it be no. How does that help you?
So just to go back, I understand the question, but I just want to say something about the framing, because our learned friends say that the Act seeks that in certain circumstances there must be nil compensation. That's not what the Act seeks. As the court, I know the court is alive to that. The Act simply says that in certain circumstances, let's just go to the Act, because I think that's probably better to frame the question in light of what the Act, the Section 12.3 actually says. So 12.3, and it's important that 12.3 forms part of a whole scheme of 12. And I have already referred to section 5.1, which requires an investigation of all relevant factors before an offer is made. And that offer, when it's made, it is made in the notice of intention to expropriate with an offer of compensation. And the party whose property is to be expropriated, the right holder, has the opportunity to consider the amount offered and to decide whether to accept or not, or to ask for information. If they ask for information and ultimately says no, then you can refer that to mediation. The Act encourages alternative dispute resolution. You mediate, just like with the court now. You mediate. If the mediation doesn't succeed, then you access the court for the court to determine the amount. And the court is going to be faced again with all of those investigated circumstances to make the factual findings which NAD says at paragraph 17 that I just read. Now, we know that section 12.1, and importantly, section 5.1 says the offer must be in accordance with section 12. It doesn't say in accordance with section 12.3. It must be in accordance with section 12. In other words, it must be just and equitable, taking into account all relevant circumstances that feature in section 12, including those in 1, in 2, and in 3. It must be just and equitable compensation in terms of those factors. Now, what does 12.3 say? And it's important to read 12.3 against the long title to the Act, because the long title to the Act also makes clear that the Act is to, let me just pull it out. So the long title said, and that one can discern the purpose of the Act from the long title, is to provide for the expropriation of property for a public purpose or in the public interest, to regulate the procedure for the expropriation of property for a public purpose or in the public interest, including payment of compensation, to identify set instances where the provisions of nil compensation may be just and equitable for expropriation in the public interest, to repeal the Expropriation Act of 1975, and to provide for matters connected therewith. So part of the Act is to identify instances where it may be just and equitable to offer nil compensation. And Section 12.3 picks up on that. In the scheme of Section 12 as a whole says, it may be just and equitable for nil compensation to be paid where land is expropriated in the public interest, that is, for land reform basically, having regard to all relevant circumstances, including but not limited to. So first, it must be just and equitable in all the relevant circumstances, and the circumstances are not a closed list. So it is not an instruction to expropriating authorities to give nil compensation as long as one of the 4 factors exist. It is to assess whether, in the light of all relevant circumstances which would have been investigated, it would be just and equitable to offer nil compensation. So the question is, what purpose does it serve? The purpose of the provision is to identify, as the long title says, to identify instances where it may be equitable, just and equitable to give nil compensation given all the relevant circumstances. There's a bigger purpose. That is there for purposes of expropriation in the public interest, which is defined mainly as land reform. And the rationality standard asks whether the provision in 12.3, in other words, awarding nil compensation where it's just and equitable in all circumstances, is likely at all to contribute to land reform. That's what rationality asks. It's asked for a rational connection. In other words, is there a causal connection between the measure you adopted with the outcome you want to achieve? So And it's an objective inquiry whether there is a likelihood that the payment of nil compensation may contribute to land reform. We submit the answer must be obvious. It can. It's capable of achieving that. We don't have to show now that it is going to achieve that for purposes of rationality. All we have to show is a causal connection, the likelihood of achieving that outcome. And
it's obvious, it's obvious
so,
that it's capable of.
Yes, it's capable of contributing. It doesn't have to achieve land reform. We'll need many things to achieve land reform. We probably also need some generosity from landowners to achieve land reform. Some people must be prepared to give up one of the 10 farms for us to achieve land reform. You're not going to achieve it by paying everybody who wants kitching. So,
why is it necessary to highlight these four factors when the really says all relevant circumstances?
yes. One can ask the same question about 25.3. Why is it necessary for 25.3 to highlight the 5 factors when all relevant circumstances must be considered? It provides guidance to those who are going to make decisions. At least as a start. Start with look at this or look at that. But it doesn't mean look at that only and stop there. One can ask the same question about 25.3. And the rationality doesn't ask for necessity. It doesn't say, is it necessary to have this provision? It is rationally connected to the outcome you want to achieve. It's a low threshold. And as pharmaceutical manufacturers says, as long as objectively considered there is that likelihood of achieving the object, the standard is achieved. You just need to identify the objective and show that there is some likelihood.
And you say you've shown that in the papers.
We say it's an objective. Well, we've identified, when I come to limitation, I'll refer to what the President says about why this is justifiable. He says it is to promote, to reverse land dispossession and homelessness. That's land reform.
I'm talking about the connection.
Well, I'm saying the connection is an objective question. So you ask yourself, given what we know about what you require to succeed in land reform, that you must pay in order to acquire land to either settle people or have productive land for people. That's what you need. If in certain circumstances you may not have to pay anything, that contributes to land reform because you can move the needle. I'm afraid I don't want to say it can accelerate because it's not going to accelerate. As law review project says, it will be just one aspect assisting, as long as it assists. If it was completely unlikely to contribute, then the rationality test would fail. But as long as objectively considered, it's likely. So you're not confined to what we say. I could have a statement in the affidavit saying it is going to. That is not good enough. You have to look at it objectively. The court must be satisfied that it has that capacity. There is a rational connection. And we submit that on an objective standard, which rationality is and sets a low threshold, that is met.
But mostly you could achieve land reform without no compensation.
Yes. Yes, you can. But recall in what is Albert in the Constitutional Court that dealing with pardons, presidential pardons. Paragraph 50 to 52 cautions courts that when you're dealing with a rationality challenge, you're not asking whether there's another means for achieving the outcome. You're only asking whether the chosen means is rational. Yes, there are a whole number of ways. They've told us you can stop corruption and employ professionals to do land compensation, change government policy. All of them may be true, but they don't give you the answer whether this measure is rationally related to progressing land reform.
So the question is to whether you can afford land reform from your own budget at this stage is not relevant.
It's not relevant. But we have so many other things, pressing needs, health. America cut our HIV funding. So we have many competing needs in this country. So you can't say, well, you can afford if you cut from there and put it all in land reform. That's not an answer to a rationality challenge. A rationality challenge only asks, is the measure chosen likely? Is there a rational connection? And that's a causal connection. Is there a rational connection to the purpose you want to achieve? If there is none, if it can't contribute to land reform, then you would say there's no rationality here. But as long as it can, it may, it's likely, that's sufficient. And the argument of our learned friend for the rule of law project on the rationality as we understood it, and I just want to deal with that briefly, because we submit that it doesn't, he highlighted 2 points about rationality. He says there are 2 grounds on which the rationality, he didn't even attack this, well he did attack it on the basis that he said, we don't have expert evidence and bulk evidence telling you that the reason land reform hasn't moved is because we have to pay compensation. But I'm saying the question is the reverse, is would nil compensation contribute to, likely contribute? But he said there are 2 bases. The first one, he says, we are confused about expropriation and deprivation. And Section 12 does not distinguish between expropriation and deprivation. He may have made a far more sophisticated argument than I'm merely saying how I understood the argument, and my learned friend will correct me if I'm wrong. But there's no confusion, both from the long title and from the Section 12.3 itself, because it says it is nil compensation where land is expropriated, not where there's deprivation, expropriated in the public interest, having regard to all relevant circumstances. So the legislature is clear that the purpose is limited to public interest. And there's a very interesting argument which was made yesterday on this point, I think might have been AfriForum or Difaderland. They question why you exclude public purpose from 12.3. I would have thought that where you limit to public interest, you make any intrusion into 25.3 as minimal as possible. So you're excluding public purpose. But they think, so the criticism goes nowhere because they don't want it at all. So they wouldn't want it if it says public interest and public purpose. But they're just saying, why do you single out public interest? Well, even the Constitution in 25 emphasizes the country's commitment to land reform. So land reform is a critical issue here. It's not to benefit me, I want a farm and they expropriate and they give it to me. We are interested in the societal interest, the interest of the many. So with respect, there's no confusion there. And under limitation, I will submit that the fact that it excludes public purpose shows that it has adopted as minimal an intrusion as possible to limit it only to public interest.
Somebody argues that we must read in public purpose.
No, they said we argued that. They said we opportunistically. That's the argument we withdrew because it was because we misunderstood what IR Legal was arguing. Yes, so that argument in our heads you can ignore. In the supplementary heads we identify it and we specifically say, sorry, we misunderstood you, IR Legal, we dropped that.
So you're not seeking under 12
Yeah.
no compensation for public purpose?
No. And that's relevant for justification under Section 36. So the first argument of our learned friend for rule of law project that the legislature is confused between expropriation and deprivation is belied by the long title and the wording used in Section 12.3 itself. It's only expropriation and only for public interest. Then he said there is an irrationality because the Section 25.3 requires you to do everything, in other words, to do the whole investigation as opposed to just going to the listed factors. I have addressed the court that there's nothing in Section 12.3 and read in the scheme of the Act as a whole, starting from Section 5.1, Section 2.1, Section 5.1, and the rest of the sections which entitle an expropriating authority or indeed a court to start by the listing in 12.3. You must start with the investigation of the whole. So there's no irrationality there because a proper interpretation requires an investigation of the whole. Then he said there's a discrimination between...
Sorry, but isn't that circuitous? You start at Section 5.1 and
Yes.
you say the requirement is that the investigation take into account when suggesting or coming up with an amount for compensation. It says there, take into account Section 12, which includes Section 12.3, and also refers to just and equitable. And now, in making that offer, you're referring to the same standard that you would take into account in 12.3. Isn't that circuitous?
I may misunderstand the question, but our submission is this. So, what Section 5.1 asks you to do as an administrator is that you must have all the facts investigated, everything, including those facts that may be relevant to a listed fact or an unlisted fact. Because when you start out as an investigator, you don't know. And there are all different kinds of powers of entry into properties to gather information. All the rest of that must be gathered. Once you've gathered that information, then you do the evaluation as to what you must offer. And that evaluation may yield a number or a zero, but it is informed by all relevant circumstances. All that 12.3 guides is that it may, in the circumstances, be just and equitable to award nil compensation, but it is not dictating the outcome. That's the point. It is not dictating the outcome. The outcome must follow the scheme that the Act says it must follow. So just and equitable is the yardstick at the end, but there is a process of investigation, gathering all the facts, and then what is just and equitable first to the administrator, then to a court, and then maybe to a court on appeal. But that's the discipline. You can't get out of that. That's what the Act requires. And here it's very important also to highlight what we say in the supplementary heads with reference to Chisuse, is that when you're faced with a challenge to Section 12.3, the first task for the court is to interpret the section. You must give it meaning first, and then having settled on that meaning, ask, does this meaning render the section in breach of Section 25.3? That's the next question. And in the interpretation process, you have to, if the section is open to more than one interpretation, others say it is an instruction. We say it is not an instruction because it doesn't dictate an outcome. It's open to both. One of those is consistent with the Constitution, the one we submit, because it is in line with the constitutional standard and norm in Section 25.3. The court must prefer that interpretation. And that also is dictated to the court under 39.2 because it requires the court to prefer an interpretation which better promotes rights in the Bill of Rights. We better promote the protection in Section 25 by not reading 12.3 as an instruction, but as simply a guide that says, in these circumstances, but you still have the bigger exercise to conduct.
What is nil compensation? What is the meaning of the phrase?
So, our submission is nil compensation means the exercise has produced a zero as a number that can be offered. No, has produced no justification for any number above zero.
What did you say? Number above?
Zero.
Oh.
Yes, zero. Oh, sorry, yesterday we had about a number below zero.
Yes.
There might be negative and this, but I'm just talking about a number above zero. So if the exercise justifies an outcome which is a number at zero, not above zero, then that's nil compensation.
Is it a fancy way of saying you get nothing?
Perhaps. No, to distinguish it from a legislation which says you can expropriate property without compensation. is different, because that would mean that you don't even have to consider whether compensation is due or not due. So it dictates where you start. If the legislation said, in this circumstance, you can expropriate property without compensation, that would be a direct affront to Section 25, because nil must be an outcome of an exercise to get at what is just and equitable. So it can't be an instruction that it's without compensation. That's what they say was attempted in the amendment to the Constitution. But that's not the matter. That's not what is before the court. It's not the attempt. What you are concerned with is interpreting this legislation, which has been successfully passed and assented to by the President.
So it's emphasizing the process, that it's the outcome of a process which takes into account just and equitable.
It's got both a procedural and substantive element. The procedural element is what I outlined. The Act tells you where you start and where you end. But the substantive element is what informs the outcome, is the constitutional standard of just and equitable with reference to all relevant circumstances. So you can't have I beg your pardon, Justice.
Sorry, please finish.
If the nil compensation is not justified when you have regard to all relevant circumstances, then that is not compensation in line with 12.3.
But it's still a fancy way of saying you're getting nothing, not so.
I don't disagree that nil means you get nothing. But
nil compensation.
Sorry.
Nil compensation is
that,
what I'm asking about.
So that you get no compensation. Yes, you get no compensation if it's nil.
Which means nothing.
Yes, that means nothing.
And because putting on a label that it's compensation doesn't make it.
But what it does for the constitutional scheme, in the constitutional scheme and the constitutional norm is, what is constitutionally valid is compensation that is just and equitable. So nil compensation requires you to ask, as an executing authority or court, what would be just and equitable compensation in this case? And you would look at all the factors. If you arrive at nil, it must be borne out by the facts which are proved and the evaluative exercise of the balance between the interests of the individual and the public interest.
Yesterday we heard that the payment of no compensation after the process of going through everything in the Wayne process is inconsistent with the scheme of the Act.
No, it's not.
That just doesn't make sense.
Yeah.
Because staff fees and add-on. So when you look at payment, and payment has to be something that's given, when a notice has to have a payment, you're paying nothing.
No.
So how does it fit in the scheme of the Act?
Let me give you a simple example. Let's assume the Act started off that the minister may owe money. The minister may owe money to X. That's the opening paragraph section. The second section says, in certain circumstances, the minister's debt may be forgiven, nil. And then the rest of the Act tells you how he must pay. And a reasonable way of understanding the scheme is that when something is due and must be paid, it will be paid in this way. But where obviously is if we get to nil and it's just and equitable under 12.3, it doesn't mean that is in conflict with the rest of the Act. And saying it's a throwaway into the Act is an add-on. It's just said there is no reference to where in the parliamentary process 12.3 was an add-on, or whether 12.3 was always part of the bill from the onset. It was always part of the scheme. All it means is where an amount above R1 is applicable, the time, manner, and payment must be just and equitable also, and it must be paid in this way. But it doesn't mean that the way, because it says you may have nil compensation, that section anyway is incompatible with the rest of the statute. Assuming that was the case, that's not a constitutional challenge. The fact that a provision is inconsistent with other provisions doesn't make that section unconstitutional. It may mean that you must interpret it differently, because a constitutional challenge is legislation against the Constitution, not legislation against legislation. And you had that in section 19.8 legislation being challenged against legislation, but you can't do that. The point is there is nothing incongruent between 12.3 and the rest of the scheme of the Act. If payment it must be made, the sections dealing with how payment, the manner of payment, and the time is determined will apply. If it's not, it doesn't apply. It's the same with Section 25.3. If certain provisions, circumstances apply, they apply. If they don't apply, they don't apply. In particular circumstances, that's a simple, coherent way of reading the provisions of the Act. So there is no inconsistency there. I was dealing with the discrimination. Oh, I beg your pardon.
So why was it necessary to enumerate 12.3 factors?
It simply provides a guide to the authority, and the legislature is entitled to provide guidelines in legislation all the time.
Isn't that the function of sub 1? Sub 1 tells us what must be taken into account. So there must be a separate function.
No, if you look at sub 1 and sub 3, if you look at them closely, you look at the factors, you will see. Sorry, I don't mean that. I don't mean it facetiously. It's just a manner of speech that.
No.
And yes, we make the point in our heads of argument, in the supplementary heads. You can look at it at 28.5 of our supplementary heads. That in fact, you will see that there is a clear connection between the factors in 1 and the factors in 3. So, for instance, the question of use in 12.1, which is borrowed from 25.3, obviously. You have current use, and you could have historical use, the current use of the property, the history of the acquisition and use. So you could have current use and historical use, and you'll see under 12.3a, that is about use.
Yes, I think we'll speak. Someone's affidavit maybe.
Yeah, it's a.
But so what?
I'll come to the so what. I'm just throwing the link first,
Right.
and then and B is also used. That's the organ of state, and then abandoning it will also go to use, and D, it's market value and state investment and subsidy. So here it's where the market value of the land is equivalent to or less than the present value of direct state investment or subsidy in the acquisition and beneficial capital improvement of the land. If you just take that. So let's take, and I'm trying to respond to the so what. The point I'm making is that 12.1 and 12.2 and 12.3 do not envisage a staggered approach. They envisage one inquiry, one unitary process in which the expropriating authority or the court considers all of these factors and decide whether what is just and equitable. So, for instance, when it's looking at the extent of, if you go to 12.1d, the extent of direct state investment and subsidy in the acquisition and beneficial capital improvement of the property and market value. So it's C and D. Then under 3D, those two are combined, but they identify a particular circumstance where the market value of the land is equivalent to or less than the present value of direct state investment or subsidy in the acquisition and beneficial capital improvement of the land. So market value is accounted for only by public money under D. So you are looking at it at the same time. You're saying, I've gathered information about direct state investment in relation to this property, and I have discovered that D applies. That this land, the value of this land, is accountable fully or exclusively by state investment. That's then if you are an expropriating authority or a court, you might ask yourself, would it be just and equitable in this circumstance to award nil compensation because you have this guideline? But then you know, in arriving at that conclusion, the answer is not simply because D is there, is nil. You must look at all relevant circumstances, including those that are not listed, which may point against it. He might say, yes, that is true, but I can explain. I have paid more than the market value and state investment in rates and taxes. We had some of it said here yesterday. I've paid a lot in this land which you can't see or which you don't see. Here it is. You'll take that into account. That might cancel out the possibility of nil compensation. But practically, that's how they would interrelate. And that's how you would, as an expropriating authority or a court, look at this. It is not a staged process. It's not, as others suggest, you get a request for expropriation, you go to section 12.3, you say, aha, D exists, nil. No, that's not the proper exercise of that power. That doesn't mean the act is unconstitutional. It means the expropriating authority has acted unconstitutionally, and that act is open to review by a court and declaration of.
Oh, so sorry.
I beg your pardon, Justice. No.
When you say they're related, these sub 1 and sub 3, do you mean sub 3 codifies what's in sub 1?
I wouldn't use.
Or do you mean that you're reading the same thing twice?
No, I don't mean it qualifies. I don't necessarily mean you're reading the same thing twice. What I mean is there is a connection. They are related. So if you're asking the question under 12.1d, right, the facts you uncover might answer 1D and 3D at the same time. So you might answer C, 12.1c and 12.1d and 3D at the same time. Remember, these factors are sometimes working against each other. So
what's the point then? What's the point of creating a nil compensation list?
It's a guide.
If they are related.
It says to the executing authority and the court, when you're looking at market value of the property and extent of direct state investment, and you're deciding on just an equitable compensation, there may be a circumstance where that might be nil in this identified circumstance, but for you to reach that conclusion, you must look at everything and conclude that it is just an equitable. It's a guide. There's nothing unlawful about it. The legislature is entitled to provide guidance to decision makers. In fact, most functions, the legislature acts well when it delegates a power to somebody else or empowers an authority to perform a function, it provides guidelines for the performance of that function. But the fundamental point here is that the constitutional standard of just and equitable in the light of all relevant circumstances remains the controlling principle even under 12.3. And that does not depart from the Constitution, the constitutional standard under section.
The argument has been that 12.3 is a thumb on the scale. The other argument is that it signals to the administrator that you have to give some importance because it is in legislation, and therefore you must take it into account. And so, why was it necessary to, given these examples, without, as it appears to be argued, that the legislature wanted to point very specifically to what it thought was important?
So there are two degrees of that argument. The first is that the legislature is instructing an outcome. We say that is not the case. It's because the provision itself makes it clear that nil is not an automatic outcome merely because of the existence of a factor under 12.3. That's the first. Then they say, well, maybe it's not dictating an outcome, but it is privileging the named circumstances. It is, others say, signaling, but we submit that it is not privileging, which will be a stronger version of it, because it requires that all circumstances be considered. And the standard is just and equitable. So it's not privileging the named circumstances in the same way that 25.3 is not privileging the named circumstances. It's just...
Isn't the fact that the legislature specifically highlights these factors indicative that when you weigh up all the factors, that these four factors must be given additional or heavier weight when weighed up against non-listed and non-named factors?
Yes, that's the right question. It is not giving it any heavier weight. As was said in the case law regarding 25.3, that naming factors doesn't mean they enjoy any hierarchical prominence. They are considered with all others, including those that are not named. And that's the same with 12.3. 12.3 doesn't, it names but says even the unnamed ones must be taken into account.
But this is not just a list that says take these into consideration. This is a list that says it may be just and equitable to award 0.
Yeah, but it says having regard to, that's taking
Yes,
into
yes,
account.
Yes, but it's giving pointers to where you might reach. That's the issue.
Let's deal with the language of pointers and signaling. It is not an unlawful or unconstitutional signaling of any kind when a legislature says, when you may in certain circumstances reach this outcome, if having regard to all circumstances, that outcome is just and equitable. I'm going to list circumstances that we as the legislature think may be relevant to that outcome.
Isn't it even more important than for the court to have been told what those considerations are? Or do you think you have? You said you're still going to go to your paper.
No, I'm not following the question. I beg your pardon.
The justification for the legislature highlighting these factors.
Oh, that's the rationality point
Yes,
about these
You
factors.
said to me earlier, you're going to take us there when we get to section 36, I think you said.
No, just correction. So I said the rationality of the individual factors, my learned friends, Mr. Mukwena and Masuku, will address.
Oh, I see.
Because in their affidavit, their clients deal with those factors.
Okay, I beg your pardon.
But I'm dealing with the scheme, if I can put it like that, without saying, should this factor have been chosen? Is it rational to have chosen this factor? I'm not dealing with that point. I'm dealing with the exercise of the power that is in 3. But in 36, what I was going to deal with is the rationality of the rational connection between the provision and the purpose of public interest. That's what I've sought to make the submission already when I was dealing with rationality as the rule of law submits, because it's the same standard. Rationality doesn't change because it's in 36. It's the same standard. So if we are good for the challenge under rationality for the, as my learned friend Mr. I must remind myself. I can't keep doing this. If we are dealing with rationality under 36 or under the rule of law project submissions, it's the same standard, doesn't change. And what we are submitting, I'll come to that just to remind the court of what I'd said, but I've said it. The only thing I haven't dealt with on rationality is the idea that there's a discrimination between foreign investors and South Africans. And I can deal with that if I don't know where we are in terms of lunch and time, but
Still wait, first one.
First one.
I'm sorry, I didn't catch time at that time.
Yes.
My sisters were nudging me.
Yes.
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 my fault.
So I was just saying the only part of the rationality challenge I haven't dealt with is the foreigner versus local, and that's a short point. And then I will tell the court where I am in the argument.
Thank you. We adjourn until 2:45.
As a court. Thank you, Justice Saldanha. So I had, I think I was closing up on the rationality issue. I had dealt firstly with the fact that there's a rational connection with the object of the section, land reform, and also that it's rational. The challenge that is not rational because you're not required to do everything is incorrect, because you do, in the scheme of the Act, have to do everything, and that there's no confusion about deprivation and expropriation. And the last one, which I understood Mr. Perumal Sami to have said, reminded myself, it was that it results in a discrimination between foreign investors and local South Africans, because foreign investors who invest under bilateral investment treaties would get a higher standard or get at least get compensation, whereas a local might get nil compensation. Well, the first point to make is you only have unfair discrimination if the two you are comparing are comparable or are in the same class. So they must be like for like. That's the right word. It's not like for like what he's comparing, because foreign investors are governed by bilateral investment treaties to which international law applies, not domestic law. So you can't say you're expropriating property where international law applies and justify it by reference to your domestic law, which is the Campbell case, the taking of the farms in Zimbabwe. In order to avoid expropriation, Zimbabwe changed the law and said you can take without compensation. And the problem with that is the denial of justice. Under international law, you can't do it because the international norm applies. But here is different. You're dealing with domestic expropriations to which domestic law applies. Then Section 25 applies and 12 as per the Expropriation Act. And so they are not comparable classes. You can't have unfair discrimination. And then the unfair discrimination case is also not properly developed, because to have proper unfair discrimination on an unlisted ground, you have to follow that Hugo test, if it's an unlisted ground, to show that this is a distinctly vulnerable group that you're talking about.
Nationality is one of the listed grounds.
Yes. If it is on, but citizenship, I can't recall if it is a listed ground, but assuming it is, the point is not like for like. And so they're entitled to international law protection, but here international law applies subject to the Constitution, as I've indicated. So that is the case on the rationality. I just want to point the court to our supplementary heads where we deal with the proper interpretation of Section 12.3 without going through what I've already done. What the court has done is got me to summarize the argument without taking you laboriously through the supplementary heads. But it's important just to point to the court where we say what we say. And that will be from paragraph 8 of the heads. The preceding paragraphs just explain why we filed supplementary heads. And what we do over the page at paragraph 9 is to identify the legal authority that when a court is faced with a challenge to the validity of a statute, the first thing to do is to interpret the statute, and to do so following the rules of interpretation, including the constitutional requirement that if there are two possible interpretations, you take one that's consistent with the Constitution, and under 39(2), you take one that better promotes rights in the Bill of Rights. And if the impugned provision is reasonably capable of a meaning that is constitutionally compliant, then the challenge fails. And we've referred to that at paragraph 12 by reference to the Sushi judgment. And so, and we also highlight that this is an abstract challenge. It's not a challenge following the implementation of the Act where you're looking at facts and saying, do these facts illustrate the unconstitutionality? And the threshold for meeting an abstract challenge is high. We say that at paragraph 14 and refer to the Solidarity Union case, which they must show you that just on its face, the section is unconstitutional. And that's not a, and we say on a proper interpretation, you can't say that. And then we go to the scheme of the Act to show that section 12.3 is capable of a constitutionally compliant interpretation. We start with the preamble, the long title at paragraph 16, that it also says it's only identifying instances where nil compensation may be just and equitable, but not that it is an instruction. And then we go to 2.1 that prohibits arbitrary expropriation, 5.1 that obliges investigation. I've dealt with that in full. And 5.1c at paragraph 20, we summarize what that section really means. And we say that it would not be constitutionally compliant and would be a breach of section 5.1c if an expropriating authority simply starts from considering that any of the circumstances in 12.3 A to D exists and that the offer of compensation must be nil. That's not what the Act requires. All facts must be investigated, and we deal with that. And the court does the same under paragraph 24 of the supplementary heads. And we say that what section 12.3 merely expresses is that there may be exceptional circumstances where even applying 25.3, you might result in nil compensation, maybe just and equitable when you take all circumstances into account, and it simply provides a guide. And it's not prescriptive, it's not an exhaustive list. I'm looking at 26 and 27. And so we say, and this was in response to the IR Legal's argument that section 12.3 appends the principled hierarchy in section 25.3. And we say it doesn't do that because, firstly, it is a law of general application. You had an argument about that, that's in section 19.8, let me not confuse things. It's a law of general application. It prohibits, specifically says in section 2, it prohibits arbitrary expropriation. It authorizes expropriation only for a public purpose or in the public interest. And it requires that compensation must be just and equitable and requires an inquiry into that, which is facts-based, both in relation to the listed and unlisted facts. And I've made the submission about the relationship between the factors in 12.1 and 12.3, and why those factors indicate that this is a unitary assessment. It's not a staged assessment. You're looking holistically at all the factors. Yes.
Paragraph 25, which is supplementary ends.
Yes.
And it says over the sections 12.3, it has to give expression to what the courts and the parties.
Oh, I'm wrong. I'm wrong about all the parties. Some of the parties. I corrected it in manuscript here, but I didn't say it. So some of the parties accept that you could have nil compensation, even applying 25.3. Others say that would be inconsistent with 25.3. That's corrected. And the courts also requires qualification. I will refer to the judgments when I deal with section 36, and the court will see in what context they said you could have no compensation. But I accept, Justice Saldanha, that is an appropriate qualification, correction rather. And then I've referred to 28.5, 28.6. I've referred to that and I've dealt with it. 28.7, so we say the assessment is done in the light of all relevant circumstances, and the controlling principle remains justice and equity in the context of all relevant circumstances. So we say when you reach that point, you ask yourself, what does section 12.3 take away from the constitutional standard in 25.3? And our submission is it doesn't take anything away because it retains the just and equitable standard in the light of all relevant circumstances. So there is no inconsistency between those provisions, and therefore there can't be a limitation. Then you've had argument that but a civil servant might abuse the provisions. It is true. It's true of many legislation, that many statutes, that functionaries may abuse the legislation, but that's not the standard for assessing constitutional validity, and that we refer to that at paragraph 32, potential abuse, and we give the references to the relevant authority, State versus Van Rooyen, Bernstein and others versus Bester, and a South African Police Service versus Public Servants Association. That's the case we cite at the foot of page 10, at the last page. So that's our submission, is that the section is compatible, can be read compatibly with the Constitution, and therefore there is no limitation. But we also accept that the court might take the other interpretation and conclude that it is not, it takes away from the right to just and equitable compensation merely by contemplating that you could have nil compensation. And we address that. And that's the one that I tend to, which is then we must satisfy the limitation under Section 36. And if there's a conflict, it means there's a limitation. Now, the Constitutional Court in F&B, it is in our bundle of authorities we've ended up at page 790. I'm not going to ask the court to go there. At 790, at paragraph 49 specifically, you will see F&B was one of the first cases to give meaning to Section 25.3. And so it had to look at foreign jurisprudence, and it did an exhaustive examination of the position in foreign countries to reach a conclusion at paragraph 49. And I'm going to read that conclusion, which the court will see at paragraph 49 of that judgment. It says the subsections which have specifically to be interpreted in the present case must not be construed in isolation. That's Section 25, but in the context of the other provisions, 25.3 rather, but in the context of the other provisions of Section 25 and their historical context, and indeed in the context of the Constitution as a whole. Subsection 4 to 9, all in one way or another, underline the need for and aim at redressing one of the most enduring legacies of racial discrimination in the past, namely the grossly unequal distribution of land in South Africa. The details of these provisions are not directly relevant to the present case, but ought to be borne in mind whenever Section 25 is being construed, because they emphasize that under the 1996 Constitution, the protection of property as an individual right is not absolute but subject to societal considerations. And then this is repeated in Hafichi, in the Hafichi judgment, which is in our bundle at page 966, at paragraph 30 is the relevant paragraph. It says the protection for the holding of property is implicit in Section 25. Section 25.1 must be construed in the context of the other provisions of Section 25 and in the context of the Constitution as a whole. Sections 25, subsection 4 to 9, underline the need for the redress and transformation of the legacy of grossly unequal distribution of land in this country. The historical context in which the property clause came into existence should be remembered. These provisions emphasize that under the Constitution, the protection of property as an individual right is not absolute but subject to societal considerations. Then in F&B, at paragraph 97, it specifically said that you could have legislation taking away the right to compensation. And it says that at paragraph 97, that judgment, I've already given where it is in our bundle. It's page 790. But it says this at paragraph 97, the formulation of property rights and their institutional framework differ. It did this after looking at all the foreign jurisdictions. The formulation of property rights and their institutional framework differ often widely from legal system to system. Comparative law cannot, by simplistic transference, determine the proper approach to our property clause that has its own context, formulation, and history. Yet, the comparative perspective does demonstrate at least two important principles. The first is that there are appropriate circumstances where it is permissible for legislation in the broader public interest to deprive persons of property without payment of compensation. And that statement is repeated in Agri SA at paragraph 99. I didn't give the page number for Agri SA in our bundle. It's paragraph 29. It's page 29 of our bundle. At paragraph 99 of that judgment, the Constitutional Court says the parallels with the situation in our country. This was referring to East Germany after the fall of the Berlin Wall and expropriations in that context. It says the parallels with the situation in our country are striking. Property derived from a tainted past, the challenges of transformation, and the demands of justice.
I'm sorry, what are you reading from?
I'm reading from Agri SA paragraph 99.
99.
Yes. It says the parallels with the situation in our country are striking.
What page is Agri, sorry?
Agri SA starts from page 29. So paragraph 99 would be at page 044 of the bundle. And you will see that that leads up from a discussion of the German position, which allows for expropriation without compensation in some instances. And what the court says at paragraph 99 in Agri SA is the parallels with the situation in our country are striking. Property derived from a tainted past, the challenges of transformation, and the demands of justice. In its particular context, the ECHR, that's the European Court of Human Rights, decision may be seen as refusing compensation even where there has in our language been expropriation. This recognized the possibility of expropriation without compensation in FNB. So it's referring back to his decision in FNB. And the same result that I have reached by a direct comparison in kind approach may be reached by this more conventional route on a case-by-case basis under the MPRDA. Recall under the MPRDA, it wasn't monetary compensation, but compensation in kind, and whether that's consistent with our constitution. And they say, well, you could have circumstances, in fact, where legislation deprive parties of compensation. So, and then in Nhlabathini, that's the Land Claims Court, that we have also included in our bundle of authorities, the court will find at 1251. And that was expropriation of property for purposes of burial sites by people who had lived on the property and were working on the property. And you will see in that judgment that it dealt with ESTA. ESTA allowed for expropriation without providing for compensation at all. And the question was whether that is permissible under the Constitution. And the Land Claims Court at paragraphs 42 to 43 said that it is permissible, is a permissible limitation provided it meets section 36 proportionality test. And at paragraph 42 it said the question therefore is which of the two possible interpretations is more compatible with the Constitution as a whole. Allowing compensation to be fixed after expropriation. Sorry. I'm maybe reading a wrong one. Sorry. I'm not reading what I'm promising to read.
What page are you reading from?
Yes. Now I'll get to the one. Yes. It's not paragraph 42, it's paragraph 32. Paragraph 32 to 34. I was looking at a different one. Paragraph 32 to 34. In that judgment, the court says, if a statutory provision which allows expropriation does not provide for compensation, it can have several repercussions. It could be that the provision contains an implied right to compensation, or that a court might have regard to such a right might have to read such a right into the provision, or that sections 25(2) and 3 of the Constitution provide a right to compensation. Where an obligation to pay compensation is incompatible with the essence of the permitted expropriation, it could be that the authorizing statutory provision is invalid. It could also be that the absence of a right to compensation is justifiable under Section 36 of the Constitution. And then it says, this is what Section 36 says, and then it refers to Ackerman J in First National Bank, says, Ackerman J stated in the First National Bank case, neither the text nor the purpose of Section 36 suggests that any rights in the Bill of Rights are excluded from limitation under its provisions. On the contrary, Section 25(8) of the Constitution is explicit in making Section 36 applicable to land, water, and related reform measures. Despite the dictum by Akaminche, no final decision was taken by the Constitutional Court on the point to what extent an infringement of a right to property which is protected by Section 25 can be justified under Section 36. Professor van der Walt, who is also relied on by AfriForum, I think, or van der Land, in his book on the property clause, argues convincingly that none of the limitations on the deprivation and exploitation of property contained in Section 25 are immune from the provisions of Section 36. Most South African authors accept that the general limitation provisions of Section 36 and the specific limitation provisions of Section 25 apply cumulatively. We share that view. The limitations on the right to expropriate, which are contained in Section 25(2) and 3, particularly with regard to the purpose of the expropriation and the payment of compensation, are important when deciding whether a statutory right to expropriate outside of those limits, in casu, to expropriate without compensation, can be justified under Section 36. It is significant that not only Section 36, but also Section 25(3) and the preamble to Section 6(2) of ESTA requires a balancing of interests between affected parties. There can be circumstances where the absence of a right to compensation on expropriation is reasonable and justifiable and in the public interest, which includes the nation's commitment to land reform. The statutory obligation of a landowner under Section 6(2)(da) of ESTA to allow an occupier to appropriate a grave site on his land without receiving compensation is, in our view, reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom, having regard to the following circumstances. The right does not constitute a major intrusion into the rights of property, that's the minimalism. The right is subject to balancing with the rights of the landowner. In some circumstances, the rights of the landowner might override the right to appropriate the gravesite. The right exists only where there is an established practice in terms of which the owner or person in charge or his or predecessor entitled routinely gave permission to people residing on the land to bury deceased members of their family on that land. And the right will in many cases enable occupiers to comply with their religious or cultural belief that deceased members of their family must be buried. So basically, but those will be the second last considerations are very unique to the case, not applicable generally. But it makes a point that, which is important, is that there may be circumstances in which legislation can permissibly deprive persons of compensation in the case of expropriation. And we mentioned an additional point before I come to whether we can justify this, is that there's also an argument that you don't need Section 12 as a whole because 25(3) is there already. But that was, I've shown in FNB and Agri-SA that they've referred specifically to 23(5) and 8, that those envisage additional legislative measures which can be taken. But specifically in Hafeji, in Du Toit, which is at page 470 of our bundle, Justice Langer, then acting CJ, although in the minority, made clear, in line with FNB and the other cases, that Section 25 expressly contemplates legislation to give further detail to its provisions, which may limit Section 25 rights, provided the limitation meets the requirements of Section 36 of the Constitution. And you will read that in paragraph 82 of that judgment, which you'll find in our bundle at page 470. And that express contemplation, as we have said, is in Section 25(5) and 25(8). And the court has read those, but what 25(5) says is the state must take reasonable legislative and other measures within its available resources to foster conditions which enable citizens to gain access to land on an equitable basis, land reform. And then 8 says, no provision of this section, i.e. 25, may impede the state from taking legislative and other measures to achieve land, water, and related reform in order to redress the results of past racial discrimination, provided that any departure from the provisions of this section is in accordance with the provisions of Section 36(1). So explicitly permitting a limitation of 25, provided only that it meets the test. And the test under Section 36(1) is a proportionality test. It's not a rationality test, it's a proportionality test. And it has been expressed in many cases. I can refer the court to a recent not recent, but one of the judgments of the SCA which cross-refers to a constitutional court judgment where the test is formulated is Van Breda, VANBREDA versus Media 24 Limited and others. There are two cases, the consolidated case, National Director of Public Prosecutions versus Media 24 Limited, is the same case. And it's 2017, Volume 3, all SA at 622, and the relevant paragraph is paragraph 60. It's quoted from State v. Manamela in the Constitutional Court, and the court will find that reference to Manamela at paragraph 66. It is this: the approach to limitation is therefore to determine the proportionality between the limitation of the right, considering the nature and importance of the infringed right on the one hand, and the purpose, importance, and effect of the infringing provision, taking into account the availability of less restrictive means available to achieve that purpose. So that's what the exercise requires of the court to do. And the President did, in his answering affidavit in the AfriForum case, explain why he submits the limitation is justifiable if there's a limitation. And that the court will find at 004-24, and it's from paragraph 67. It's actually one paragraph. So it starts off by repeating the argument I have made, that there is no conflict. But if there is a conflict, it says, to the extent that there is a limitation of rights in Section 25 or other provisions of the Bill of Rights, such a limitation is justifiable under Section 36 of the Constitution. And it says, first, I accept that the right in Section 25 is important, but so are other rights in the Bill of Rights, which the right to expropriate land in the public interest and for a public purpose is intended to achieve, given the history of land dispossessions and lack of housing. The preamble to the Constitution records this ugly history and the need to reverse its persisting pernicious consequences. The other rights in the Bill of Rights that are referred to include those in Section 9.2, that's equality, 10, dignity, and 25 and 26 is the housing. Second, the limitation is extraordinarily important given that what I have said immediately above and in the preamble to the Constitution, in other words, to advance transformation, to undo the persisting pernicious consequences of our history. And third, the nature and extent of the limitation is itself limited because courts are enjoined to strike an equitable balance between the interests of the public and those affected by expropriation, as already explained. And that is because Section 12.3 itself imports the standard of justice and equity having regard to all relevant circumstances. So it limits the right to compensation as little as possible because courts and expropriating authorities are still required to engage in that complete exercise. Fourth, there is a rational relation between the limitation and its purpose, and I addressed the purpose earlier about land reform, and that rationality sets a very low threshold. All it asks is whether there's a rational connection between the purpose of land reform and the limitation that you find in Section 12.3. It's an objective test. It's not who has best testified before this court. It's the court makes a value judgment on whether there is a likely connection, causal connection. And then fifth, the legislature has adopted less restrictive means to achieve the purpose given the nature of the considerations to be taken into account as discussed above, and the court's role to achieve an equitable balance between the interests of the public and of those affected by expropriation, as also discussed above. All of those considerations that our learned friends yesterday argued that if you apply 12.3, you're going to ignore. Actually, they're not ignored because if they're relevant, they're taken into account because the list is not closed, it's not exhaustive. So we submit that we easily pass the proportionality test under Section 36 of the Constitution, to the extent that there is a limitation. And I've addressed the unfair discrimination because they also raise it in the context of limitation between foreign investors and South African citizens. They're just different classes of people. So the upshot of our submission is, if you find a departure from 25, it's a limited departure because of the importation of the constitutional standard in Section 12.3. And I've addressed the international law position. International law doesn't affect the limitation analysis because Section 232 of the Constitution says customary international law applies unless it is inconsistent with the Constitution. If there was a principle of customary international law which says no state can limit rights to compensation in its constitution, if it said that, and we have adopted a limitation in Section 36, read with 25, 5, and 8, that principle will be inconsistent with the Constitution, and therefore the Constitution prevails and not that standard. The same applies to conflict with legislation. It says so in Section 232 of the Constitution. So we submit with respect that the constitutional challenge to 12.3 should fail either on the basis there is no conflict with 25.3, the constitutional standard permeates 12.3, governs 12.3. Alternatively, if there is a limitation to a right to compensation, it's just justifiable under Section 36, and I've given you the case law which shows that that is permissible, and the law itself, the section itself says so. Then I conclude on 12.3 and I move to 12.2e. Now 12.2e is a challenge raised only by IR Legal, or for whom our learned colleague Borstrom argued yesterday. Now he said in argument, and I'm not going to be able to reproduce verbatim what he said, but I'll try to paraphrase. He said 12.2e is vague because it lacks any temporal restriction. There's no time limit. It just says anything done with the object of must not be taken into account. He said that is vague, it's too broad, it's unconstitutional. He said he accepts 12.2d. You recall that. He said he not only said he accepts, he said it is a sensible provision. That is the one which has some temporal limitation, and says in certain circumstances where it's agreed, the improvements can be taken into account. All good. That's what he said. But that's not what the case he pleaded. IR Legal pleaded a completely different case, and I refer the court to the founding affidavit at 001-146. And I can summarize. Their case was there's a conflict between 12.2d and 12.2e. Because there's a conflict, they are vague, irrational, and unconstitutional. And you will read that at page 001-146 at paragraph 38. It says, IR Legal's first challenge to the constitutionality of the provisions of the Expropriation Act relates to section 12.2e of the Expropriation Act, which stipulates, and then quotes. And then it says, the aforementioned subsection is in contradiction with subsection 2.2d of the Expropriation Act, which provides, and quotes. And then says 40, section 12.2e of the Expropriation Act prevents anything done with the object of obtaining compensation, therefore, from being taken account of in determining compensation. That contradicts the proviso of section 12.2d, which allows improvements made and agreed to in advance with the expropriating authority, and improvements made pursuant to antecedent obligations to be taken into account when determining compensation. 41. The conflict between these two subsections renders them vague, irrational, and unconstitutional. 42. The effect of the completing provisions is that it's unclear then, so it's vague. The inherent conflict, 43, between the two subsections renders the subsections vague and therefore unconstitutional. That's the case we were called upon to meet. And we met that case, and IR Legal seemingly walked away from that one. And we deal with that case at
Have we lost Mr. Boxford?
not in that he's not in court, yes. But his junior is probably here.
Yes, indeed, my lord. Judge Saldana, the court. The both just having he's a little bit down and he will be back with us tomorrow morning.
Thank you.
Thank you. That's we're all a little bit down, but we appreciate he will be here with us tomorrow. So he's listening to me. If I'm wrong, he'll correct me in reply. We deal with that.
The burden you carry, sir.
That is the burden I make it. What is
The burden you carry is to listen and to see whether Mr. Morrison has been misrepresented. That's the burden you carry.
He has not been misrepresented.
Yes.
Yet. So
He's still listening. I appreciate. So we deal with that in paragraph in our heads at. Let me just the paragraphs 170 to 182 of our heads. That will be the main heads, not the supplementary. And we make a very simple proposition. So we say, look, a reference. So it will be in our heads. The case line reference is 018-214, but the internal page numbering to our heads is 61. 61 from paragraph 168. Yes, thank you, Justice Slingers. So we deal with that. We deal with the contradiction case that has been. We summarize it. That's what the summary, and we say it has no merit. We quote the section. The section says, in determining the amount of compensation to be paid in terms of this act, the expropriating authority must not, unless there are special circumstances in which it would be just and equitable to do so, take account of. D deals with improvements. Improvements made to the property in question after the date on which the notice of expropriation was served upon the expropriated owner or expropriated holder, as the case may be, except where the improvements were either agreed in advance or were pursuant to legal obligations. And E deals with anything else done with the object of obtaining compensation. So they cover in two different areas. Their purpose may be the same, but they are covering two different areas. And this Justice Saldana.
So assuming there is no agreement, but it is necessary improvements, as it was argued, the patio needs to be repaired, or the walkway needs to be repaired, otherwise somebody could be injured.
Yes.
And there's no agreement. What happens there?
So,
is it D or E?
So let's take it doesn't fall under D because there was no agreement, and now we are in E. In E, the improvement must be with the object of obtaining compensation. So if it's necessary improvements to property done in the ordinary course, it's not with the object of obtaining compensation. Here it's just you want compensation, so you're going to add a toilet or add a driveway. But if you're adding a toilet or driveway for convenience, you were going to do that anyway. It's not with the object of. That's the first thing. But secondly, it may be that there are exceptional circumstances why you had to improve the property. Special, yeah, it says special circumstances.
So
yes.
Is that not the hook that they're complaining of? You actually have to demonstrate special circumstances in simply making improvements to your patio or to your driveway.
Justice Saldana, he could have made that complaint. He could have articulated that complaint. But that's not the complaint he brought to court. The complaint he brought to court is the contradiction between the two sections.
He's not fine,
yes.
But he's argued it and he's given us practical, simply looking at E. So look at the practicality of E. So assuming there was no consent, you then have to jump through this hurdle with a special circumstance.
Yes. Our submission is this, Justice Saldana, and I'm addressing first the case pleaded and then I'll respond to the question. The case pleaded is there is a contradiction. There isn't, because D is limited to improvements. But the value of land may be improved by other ways other than improvements, other than the patio and so on. You could have what's the word? Changing for rezoning, precisely. Change from agriculture to business, or from residential to agriculture or to business. That enhances the value.
And that's what you may have heard in the pub. That the land is earmarked for expropriation.
Right.
It's as a result of what you heard in the pub. From some state official.
He's going to do a rezoning application.
He's going to do the rezoning.
Yes. But the rezoning will not be under D, it will be under E. Because it is not, as we understand improvements, these are additions to the property or some kind of physical thing that you do.
It's just in that challenge on its own. How is the expropriating official going to know that that's what he learned in the past? And if he simply says, my intention was always simply to apply for rezoning.
Quite.
It's not that assuming the landowner is going to appear before an administrative official placed under oath, cross-examined. No.
Yes.
He's simply going to say, it's never my intention to simply seek compensation or use the process.
Yes.
I had a genuine intention of wanting to develop the property or to apply for rezoning.
Yes.
Are you possibly going to meet that?
Can I answer I'll answer the question you asked, but I just want to submit that the question being asked demonstrates how benign the intrusion is of the section. Because in the investigation of gathering facts, it transpires that 6 months ago he applied for rezoning rights. And the expropriating authority must understand from him must establish what it was for. Was it for increasing our compensation, or was it just in the ordinary course? This is my ordinary course. I've always planned that I'm going to convert this property into business property. And unless the expropriating authority has some other countervailing facts from elsewhere, they have to accept that those are the facts. And so he would get his improvement, he would get his compensation. So I'm just showing how benign it may offend the Constitution. But to the second question, that's precisely how this legislation works. You're going to work on the trust, the bona fides of the property owners when you investigate facts. You're going to ask, is this to try to determine whether this is an improvement that must count in or count out? You're going to have to gather the facts from the person. That's what the investigation requires. I accept it's not the Commission of Inquiry, which the current one where people don't want to go to. It's simply that you're going to gather information. But that shows. Yes, it's in 12.5. I have gone to, sorry, not 12.5, Section 5, where I referred to about investigation. That's what the expropriating authority would do. But it just illustrates how the complaint is it can rise to a constitutional challenge, where you're simply saying, look, I can add a stoop to my house, and there's potential you may deny me under E or under D. But it's easy, if it wasn't for that object, to say, I was just, in the normal course, where is the countervailing fact going to come from other than from you, unless there are other records?
What's the threshold, Mr. Unechi, for the establishment of a fact in the inquiry?
It would be just balance of probabilities. So you can test, but often when you don't have anything else to go on, you can't reject what you have, but because you must reject it if you have another thing that contradicts what you have. I'm just saying at the highest it will be a balance of probabilities. Even the court establishing facts is a civil proceeding, it will be on a balance of probabilities.
It's easy, of course, to do that for administrators.
It is. Unfortunately, you can't get courts making the first decision to offer compensation because you just don't have the capacity to do it. You're overworked as it is. You don't want to administer expropriation. So it must be done by somebody subject to checks by the court. And that's how our system works. Otherwise, administrative decision makers make complex decisions about whether they're going to close this road and turn it into a national road, and whether it's going to be a toll road or not a toll road, and you and I are going to pay in order to pay for that improvement. These are far-reaching decisions they make. And then they come here, and outer is one case which involved an administrator deciding on a toll road, went all the way to the Constitutional Court on challenge, and the Constitutional Court said there was nothing wrong with what the administrator did. There was a challenge in the SCA. It also ended with the review being out of time. But the point is, there are many judgments in our jurisprudence in which administrators made judgments which this courts, up to the highest court, have said this is consistent with the Constitution, and that's what we want. They must do their work, and the judiciary does its work.
Seems to me that I raise this because the debate goes around the examples given.
Yeah.
And the examples are given to demonstrate a simple absurdity.
Yes. You see, that's the problem with and that's how the arguments have been presented. You can't argue a constitutional challenge by giving 100 examples, because there are always different permutations of examples. I gave the court a combination of facts which, on first blush, could justify nil compensation. But somebody can throw in another factor and other factors which make the same point, the same set of facts now no longer just and equitable. But that is the purpose of the Balancing Act. You put everything into the pot.
It must establish the principle.
Establish the principle.
Enough to
Yes.
deal with the details.
Yeah. It doesn't help to tell us that a statute is unconstitutional, because if you look at 10 examples, it's unworkable. No, show us at a facial level, because this is an abstract challenge, why it is breaching a constitutional norm or breaching a right in the Constitution or a specific provision of the Constitution which prohibits what is being done. That is the constitutional challenge. You put the constitutional yardstick and you measure the legislation against it. Examples, maybe if we had a real expropriation and the effects, then you can talk about examples, this example there, but we are not talking about an expropriation. That is still to come when the Act is in force. So the permutations are... Yes.
You saw the debate yesterday that we had with Mr. Boxell.
Yes.
Throwing up, when I said that the administrator was throwing his hands up in the air,
Yes.
literally what he was showing us.
Yeah.
Shrugging the shoulders, saying, what's the purpose of this, why do I do it? All of these circumstances placed in the legislation is irrelevant, unnecessary. In fact, he dismissed it off as Chippy's rappers.
Yeah, that's...
So, that's just the extreme.
Yes.
I'm saying that's the argument made about why this is unnecessary. And because it's unnecessary, it's unconstitutional.
But where is the constitutional standard which says if something is unnecessary in legislation, it's unconstitutional? There's nothing. It must either breach the Bill of Rights, it must either be irrational, not unnecessary, irrational, or it must breach a constitutional provision.
In fact, the word repeatedly used was surplusage.
Well, if there's subterfuge, is that the right? Yeah, subterfuge.
Yeah.
Yes. If that is the case, there's also no constitutional standard which says if the legislature speaks too much than it should, that's unconstitutional. There's nothing like that. The over-inclusion is not unconstitutional on its own.
Part of the debate is this. When he was asked about why is the Chippy's rapper unconstitutional, he was slipped a note by his assistant.
Yes.
And said, because it's irrational.
Yeah, but
that was his response.
If by Chippy's rapper he meant it's one sentence in a Chippy's saying, "Did you know that?" The fact that is one sentence of the fact that is yes, but
unnecessary.
Yes, unnecessary. Well, unfortunately, that's not the standard to measure constitutional validities. The standard legislation is only measured against the Bill of Rights a principle of the Constitution or constitutional norm or standard of rationality, not even reasonableness. The reasonableness only features where the Act says, where the Constitution says the state must take reasonable measures, and then you measure whether those measures are reasonable, like in the socio-economic rights. But as for legislative provisions generally, the legislature can be unreasonable. The only time that it cannot, it's what it does may be declared invalid is if it acts irrationally. In other words, there's no legitimate governmental purpose to be served by what it has done, and the steps it has taken can't rationally achieve that. That's the standard, but not the Chepis. The Chepis rap is unfortunate, and the 3-page judgment and 4-page judgment just outlining the issues in this case will go longer than 4 pages with respect. And if the court recounts our history, you're in 10 pages already just talking about where we are before you get into the issues.
I think they were just
yes, absolutely.
I think
Yes.
they were simply saying it's fairly simple. So
It's not. If it was that simple, Vanderland would not have given you 3/4 of its heads on international law and only 1/4 on the Constitution. It shows that it is a weighty matter that requires proper reflection, especially given our historical context. So all of those, as the court says, the court took it with a, what's the right word? Lightly, with a pinch of salt, maybe. Is that the right expression? This is not my mother tongue, but I think that's probably close to it. So we submit with respect that the challenge based on contradiction doesn't succeed because the court is required, when it is faced with a challenge that provisions are contradictory, to first interpret them in a harmonious way. We cited authority in our heads at footnote 118, and we've included that judgment. UNICO is the last judgment in our list of authorities. It is, I'll get the page now, it's page 1407. It says specifically that where the provisions address different matters or the same matters but to different extents, there is no contradiction and they can live side by side. So that's the job of the court, is first to interpret them harmoniously. If that is not possible, then you can say they are vague and inconsistent with the Constitution. And we've given the court in the heads the affordable medicines test on vagueness, that the law does not require absolute necessity, certainty, it just requires reasonable certainty. So that we submit, that challenge fails.
So when you say they can live side by side, you accept that they can overlap, D and E may overlap?
In purpose. But they address different things. So D is specific, it's about improvements. Those would be physical improvements. And E is anything else.
So it excludes. So if, for example, if E were drafted in such a way as to say excluding the circumstances in D, anything done.
Yes. We submit that you must read it in that way.
That's how you must read it.
That actually the legislature must be taken to be sensible in making legislation and to know the law. I think that's the principle. So it knows that it cannot deal with a situation in A and deal with the same situation in B. And the court must try to give the provisions meaning which make them workable. And the meaning here is clear, is that D is about physical improvements. If it's physical improvements, you're in D. But if it's anything else, it's not improvements in D, it's something that falls in E.
And then you're going to have to demonstrate special circumstances.
Yes.
That's the complaint.
Or the complaint in the
That's the complaint.
In the argument.
Threshold
Yes.
is not just ordinary circumstances. I have a very simple explanation. My driveway was cracking and it became dangerous for children playing on it. It had to be special circumstances. And the concern was that why are you raising this bar for something that could be innocuous or no more than a few thousand rand in the bigger scheme of things? Why is this onus of special circumstances placed on the person who makes the improvement?
We have two answers to that, Justice Saldanha. The object of obtaining compensation. If the special compensation, that bar does not apply. And then in addition, special circumstances. So it's not just special circumstances for E, it's either of those two can take you out of that limitation. But I know Justice Saldanha is alive to my main submission that was not the case. We were called upon to meet.
No,
yes.
I'm saying that we would have to deal with it.
Yeah.
This one is
principle that a case for an applicant must be made in the founding affidavit. And the courts and we've referred to authorities at footnote 8, SO, which is a 2021 judgment of the SCA, and Geleke Kanse with the judgment of the Constitutional Court, and De Beer with the judgment of the SCA. All those judgments emphasize that tried principle. And they say it applies also in constitutional matters. You'll find in Geleke, in the paragraph that we referred to, Justice Cameron, as he then was, made that point that it applies in constitutional challenges, that the respondent must be put on notice as to what the challenge is and be able to respond to it. That's the first one. In De Beer, maybe the court might want to read De Beer from paragraph 82. This is a case where during COVID, there was a challenge before the High Court in Pretoria of certain regulations made by the COGTA minister. And the judge, in giving judgment, dealt with those that were challenged and then thought, well, I can see problems with the rest of the regulations and just let's not deal with them. Dealt with them and struck them off. And the SCA had very stern words to say about that. That's not a role of a judge. The role of a court is to decide matters that are properly placed before the court by way of pleadings. So that's our first answer. It's not a technical defense. It is a defense which, of course, invites the court to deal with it, but to deal with it on the basis that it wasn't pleaded, is not properly before the court. That's the first one.
So must the court not make that caveat?
That
it hasn't been dealt with in the papers.
Yes, but it was raised.
There might be a short or long answer to it.
Yes. I was going to the second part, but just to complete the first part is you can't raise the argument for the first time in your heads of argument or in oral submissions. We had that in oral submissions yesterday, that the case has shifted. That's not permissible, and all of those judgments, and especially De Beer, emphasizes the role of courts in that context. But the second point is to respond to the merit of the complaint, which is what Justice Saldanha is raising, is what if we want to express an opinion, a view, even obiter, on the fact that the challenge was in fact raised in oral argument. And our submission is the one I made earlier, is that to get out of section of the exclusion in 12.2e, there are two routes. The one is, it is here special circumstance, that's the complaint, But there's a second route to show that, no, this was just in the ordinary course to create a stoop for myself. I wasn't doing it with the object of. Because that must mean that was the primary and dominant aim for you doing the improvements or whatever you were doing to get more compensation. That's an easier hurdle we would submit, and that would make that provision pass constitutional muster. So on either account, either on it's not pleaded or on the merits we submit we should succeed. And it's not a reverse honors as you are submitted. It's not, we presume that you must prove the opposite. Recall that these are all facts that the authority must gather. They must gather and it's a gathering, fact-finding exercise. It's not a question of a reverse honors. So we submit that.
So if it's not the reverse, the expropriator will have that in the document after the investigations, because you have to give reasons for the amount offered.
Yes.
You will have to motivate as to why no, that's not been taken into account.
Precisely.
You've got to give the reasons for why it's not taken into account.
Yes.
Then the person who receives it says, well, I've read this, I now need to respond.
Yes.
And I have a special circumstance, driveway or so.
Yes. And recall that the scheme of the Act allows the owner or the right holder to ask for information from the expropriating authority when they give the offer. So you can say, how did you get to this?
So it says they told him. They told him over the fence.
Huh?
So yeah, my property is about to be expropriated.
Then you'll see, that neighbor. Yes, see, that neighbor has always been jealous of my success. And here is how I got to make the stoop. I had a plans 10 years ago and I shelved them because I didn't have money at the time. Now I have money, that's why I implemented the plan. So there could be very clear explanations for that. But the point is simply that there is no constitutional challenge there that can succeed. Then can I deal with 12.4? 12.4 justice is a matter of interpretation again, and is a matter of interpreting provisions in a harmonious way, which is what the Constitution requires. We deal with that in our heads. We deal in a longer paragraphs, but I'm not going to take the court to all of them. It's paragraph 214 to paragraph 230, and it's internal page 74 to 77. So the section, as you know, the section says, let me just get the section so I can refresh the court's memory about the section. That's 12.4. It says, when a court or arbitrator determines the amount of compensation in terms of Section 23 of the Land Reform Act, it may be just and equitable for nil compensation to be paid, having regard to all relevant circumstances. This is now, as our learned friend for AfriForum reminded us, this is judicial expropriation, or expropriation. Well, I mean, it's a determination of compensation amount by the judiciary, by a court or an arbitrator. Says nil compensation may be paid, having regard to all relevant circumstances. But the important point about the section is the cross-reference to Section 23 of the Land Reform Act. So it cross-references, and cross-referencing means you read them together. You don't read the one and say this is unconstitutional. And when you read them together, we quote a paragraph in our heads. I've given the reference where we deal with this at the foot of page 75, footnote 141, against the submission we make that where statutory provisions are in pari materia, dealing with the same subject matter, expropriation and compensation in this case, and that's paragraph 222. The court must interpret the provisions in a harmonious way. And that's, we refer to Independent Institute of Education versus KZN, the judgment of the Constitutional Court. At paragraph 38, the court says this: it is a well established to be consistent so far as possible with every other part of that statute and with every other unrepealed statute enacted by the legislature. Statutes dealing with the same subject matter or which are in pari materia should be construed together harmoniously. This imperative has the effect of harmonizing conflicts and differences between statutes. The canon derives its force from the presumption that the legislature is consistent with itself. In other ways, that the legislature knows and has in mind the existing law when it passes new legislation and frames new legislation with reference to the existing law. Statutes relating to the same subject matter should be read together because they should be seen as part of a single harmonious legal system. Here you don't even have to necessarily go through the principle to apply this, to read them harmoniously. Section 12.4 specifically references Section 23 of the Labour Tenants Act. And at paragraph 2 to 3 of our main heads, we quote from what Section 23 says. It says, owner's right to compensation. 1. The owner of affected land or any other person whose rights are affected shall be entitled to just and equitable compensation as prescribed by the Constitution for the acquisition by the applicant of the land or right in land. The amount of compensation shall, failing agreement, be determined by the arbitrator or the court. So both sections are speaking about the same thing. So when that section says, cross-references this and says nil compensation must be possible, it must be nil compensation which could be possible even under Section 23, which means nil compensation that could be possible in exceptional circumstances under Section 25(3) of the Constitution. You have to read them together. There is no conflict in that way. And you are required to do so also by Section 39(2) of the Constitution because you must read them to better promote rights. So there's no conflict there. There's no invalidity because there's a cross-reference to 23. And you can't ignore, everybody has emphasized you can't ignore the words of the statute. It's true, and that's the words there cross-reference Section 23 of the Labour Tenants Act, and you must read them together in harmony because the legislature is taken to speak consistently with itself and it knows the law. And that's the presumption.
So even if you took it out, a court, this act comes into being, a court will still have to take the Expropriation Act into account in Section 12. Would it have to?
If you took account, Justice Saldanha,
you took this out.
12.4.
12.4.
Yeah, well, so I think 12.4 just makes it clear that the Expropriation Act is the general legislation which applies to all expropriations, but it reminds the reader that where there is expropriation under the Labour Tenants Act, Section 23 governs, and where there may be nil, it must be just and equitable based on the constitutional standards.
But then you say to the court has to take into account all of the factors under 12.
Yes. So it's the same thing as Section 23 of the Labour Tenants Act says take the circumstances in the Constitution into account, all relevant circumstances, the named and unnamed circumstances.
So does that require a court not just looking at the 25(3), now we should look at Section 12, and all of it?
Yes. So the starting point is if you're an expropriating authority or an arbitrator looking at expropriation of under Labour Tenants Act, and you're considering whether nil compensation may be on all the circumstances, you're considering whether nil compensation may be just and equitable. 12.4 does nothing more than remind you that even though it may be possible, it must be in light of all relevant circumstances, as already referenced in Section 23 of the Labour Tenants Act. And when you go to the Labour Tenants Act, once that compensation to be just and equitable under Section 25 of the Constitution. So 12.4 does nothing that breaches the Constitution, because it incorporates the standard by cross-referencing to the Labour Tenants Act, because that Section 23 is very specific. It's Section 23 of the Labour Tenants Act requires, as I've read it, we've quoted from that section. We quoted the whole section. What page was that? Page 76. So it's 12.4 incorporates 23 by reference, meaning that standard qualifies whatever 12.4 says. And that qualification maintains the constitutional standards of just and equity. It does, but only where it's just and equitable after taking all relevant circumstances into account. So Justice Slingers is right. So it's now that if 12.3 was not applicable to labour tenants, 12.4 shows that even under 12.4, you could, having considered everything, come to nil compensation. That's correct. But that does not breach the constitutional standard of just and equitable in light of all relevant circumstances.
Who is the expropriator?
I think it's the labour tenants. It may be the state paying as Msiza. In Msiza, that's the labour tenants. Msiza is labour tenants. The money was to be paid by the state for the expropriation of the land on which the family had been living on for many years. So it was. In effect, I think so the court order expropriates, in a sense, because it says the state can take it and they must pay so much compensation. That's why our reference is judicial expropriation. It's not the administrator sitting in the office. I'm not 100% sure. I'll look at Msiza again. I don't want to mislead the court. But whatever happens, is the compensation amount is determined by the court or an arbitrator. That's for sure. And that may be paid by the state for the benefit of the family or the people who needs settlement on that property. And that was Msiza. My learned friend, Mr. Bishop, was acting for an amicus who challenged this thing, the amount of compensation. And yes.
It's different to what is contemplated in 12, where the expropriator is the state.
Yes. Yes.
And it's not that the person, the labour tenant, is seeking to expropriate.
Yes. But the compensate, because they probably won't afford the compensation is often paid by the state.
Who does the investigation?
It may be rural development. Maybe rural development might have an answer, but I'm not certain. We'll check this. I'm not sure. I didn't look at it in that context to see who. It may even be in the Labour Tenants Act itself that's regulated. But we can check that, and to the extent that we haven't given an answer, one of my learned friends will give the answer.
We don't have a copy of the statute to do it.
And I don't think we included it. We didn't include it. We can upload it for the court.
But isn't it then anomalous? Assuming let's wait for the statute, because
yes,
if we're talking about the investigation as being crucial, to establish the facts around expropriation.
We have included Msiza in this, have we not? In the bundle, maybe. So we'll look at it. But we'll look at that question and answer it. Yeah, it is in the bundle. In the AfriForum bundle.
Volume 2, page 976, if I may.
976.
2 of AfriForum's bundle, page 976, that there is the act.
Yes. I was on the receiving end in Msiza, so I remember it, but it's at least in the bundle.
Okay, but it is sui generis. Is it sui generis? Compared to what is contemplated in the Expropriation Act?
Probably. So it was always separately regulated by the Labour Tenants Act, I think. So, but we just need to apply our minds to that question. Is it sui generis? But the only important point about the challenge is that they challenge Section 12.4 on the basis that it unconstitutionally introduces nil compensation in labour tenants expropriations. But we say it does so with proper respect to the constitutional standard because it incorporates by reference Section 23 of the Labour Tenants Act, which itself incorporates the constitutional standard. So there's no problem.
But I understood part of the impact is also it's unnecessary to be in this act.
And we've addressed the point about necessity. That necessity is not, you don't go to court and say, this legislation is unnecessarily declared unconstitutional. If it's irrational, yes. But it's not irrational in that all it does is providing guidance. You can have different statutes dealing with the same subject matter, sometimes differently, or some adding additional considerations. That's permissible. But that's why the court will then read them harmoniously, so that they don't deal with the same subject matter in a disjointed or contradictory fashion. You read them together, reconcile them. That's Section 12.4. Then in my sequence, maybe let me deal with Section 19.8 before I deal with let me deal with. Yes, I was suggesting that in my sequence I had said I'm going to deal with the just and equitable remedy in relation to 19.2 and then go to 19.8 and the other challenges. Perhaps I should come to the remedy last. So I'm going to deal with 19.8 first. Recall that Section 19.8 of the Expropriation Act, and it's also important just to remember what it says because the argument is made. Sometimes arguments can lose track of what the section actually says. What it says in 19.8 is, despite Section 18 of the Superior Courts Act, any appeal against the decision of a court on the amount of compensation will not prevent the expropriating authority from expropriating for the amount approved or decided unless a court grants an interim interdict based on compelling prospects of success of the appeal. So what it does is it says, 18.1 says an appeal freezes execution, but in this case you can carry on executing in the case of expropriations. And they say that is unconstitutional. Why, as we understand the argument, is firstly, is unconstitutional because it changes a common law position which has been codified in the Superior Courts Act, and the Superior Courts Act is there to give effect to the court's inherent powers. But so the first submission we make about 19.8 is that argument is firstly, the legislature has the power to make and change laws. That's Section 43 and 44. And when it changes an existing statute, the new change cannot be declared unconstitutional as measured against an existing statute. That's not the measure. So that's the first answer. But in any event, that section retains the inherent powers of the court because it allows it to regulate by way of an interdict. That's the second point. But there's a second answer which is completely dispositive of this complaint. In Hafeji, which you will find in our bundle of authorities at page, Hafeji is, sorry, I missed the page number now. Page 966. You'll find at page 966 there was a challenge. There was a challenge to compensation based on, expropriation where the amount of compensation had not yet been decided by a court, but the expropriation was implemented, going ahead. And the argument was that the words subject to compensation in 25(2)(b) mean that compensation must be, the amount must be decided first before expropriation can be implemented, and that when you implement before the amount is decided, that is unconstitutional. And the Constitutional Court considered the possible interpretations of Section 25(2)(b) and said at paragraph 42 and 43 that that challenge was wrong. It confirmed that expropriation may be effected before the amount of compensation is determined. And this, we submit, would obviously include where the amount is still the subject of an appeal because not yet finally determined. And Section 19(8) says you can go ahead. So that will be in line with what Hafiji said. It said this at paragraph 42 and 43. 42, the question therefore is which of these two possible interpretations is more compatible with the Constitution as a whole, allowing compensation to be fixed after expropriation against the property owner although post-expropriation compensation burdens the property owner, making it a precondition would also burden the state unduly. This, in the end, is the compelling reason why the applicant's contention cannot be upheld. In summary, then, at paragraph 43, the provisions of Section 25(2)(b) do not require that the amount of compensation and the time and manner of payment must always be determined by agreement or by the court before expropriation under Section 25(2). B, generally, the determination of compensation in accordance with the provisions of Section 25(3) before expropriation will be just and equitable. C, in those cases where compensation must be determined after expropriation, this must be done as soon as reasonably possible in accordance with the provisions of Section 25(3). D, eviction following expropriation may not take place unless agreed upon between the parties to the expropriation or in the absence of agreement under court supervision. That's the eviction. But it's very clear that you can have expropriation before the amount is finally determined. And in this case, all that you are postponing, all that is being postponed is for the appeal court to say whether the court of first instance was right or wrong. And that would be in line with the Hafiji principle. So it's not a breach. There's a third point also, is that the court will be aware of the pay now and argue later principle in tax administration. That's the same principle. You pay now and you will argue in the appeal. If you succeed in the appeal, you may get reassessed and pay less tax, get a refund, or be told to pay more tax. Even here, if you succeed, you require more compensation because the Court of Appeal says so, you'll get more compensation. And there is no breach of Section 34 of the Constitution. Yes, that's what the answer I was going to give, because if you have nil compensation and you say I'll suffer irreparable harm, then irreparable harm by definition would be a special circumstance or a compelling reason. The same yardstick as in Section 18(3), where you want to execute pending appeal. You must show exceptional circumstances and that you will suffer irreparable harm, and the other side won't suffer irreparable harm. So in this case, nil compensation, where you can demonstrate it would result in irreparable harm, any court will say that's compelling to give an interdict.
Practical concerns raised with us over the past 2 days is what about the poor person who can expropriate and can't afford legal proceedings all the way up from the High Court to Supreme Court of Appeal and then to Constitution. So yes. It's meaningless to their right of access.
Yes. I think the legislature envisaged that because in 1903, so 1902 says That's the section I'm going to come to. But 19.2 says, if the expropriating authority and the disputing party do not settle the dispute by consensus or mediation, either party may go to court within 180 days. And then 3 says, the disputing party may, instead of instituting such proceedings himself or herself, within 90 days of the date of the notice of expropriation, request the expropriating authority in writing to institute such proceedings. And the expropriating authority must institute such proceedings within 180 days of receiving such requests. So we would submit that means it will be at the cost of the expropriating authority.
But would the expropriatee not still incur legal cost in going to court? Putting these all our case before the court, even though it may not be the party instituting the proceedings.
Well,
It has a right to put the facts that
Yes.
is relevant before the court.
The way we understand that section as the institution of proceedings by the expropriating authority means if you need a notice of motion and founding affidavit, it would be in their name. With the expropriatee perhaps providing in other words, there will be assistance to the indigent person to be assisted. And I know I can't say there's legal aid, but this provision ameliorates that, and courts will interpret what this provision means when you're faced with an indigent person who says, this is nil compensation and I can't afford it. I want to go to court, but I don't have money. The court, I believe, with my respectful submission, will not find it difficult to read this section to mean that the expropriating authority must assist the expropriatee in the manner that I submit, that they must help put together the court case, and if there's going to be counsel, help providing counsel, not put the matter together and say, we've assisted you.
Because they will only come to court when there is no agreement.
Yes.
So one can envisage that there is a dispute of fact. How does the expropriatee
Yes.
dispute of facts before the court?
Justice Lingers, I appreciate that there may be a conflict of interest, but I suppose one can say the same about pro deo counsel of old, that where you're prosecuted by the state and the state is giving you legal counsel, where's the interest?
The state is going to give counsel.
Well, that's my submission, and because it's not a matter that the court must determine now. This is not the challenge to Section 19.8 is not that it is unconstitutional because there's no assistance to the expropriatee to a challenge with the pause of 18 of the Superior Courts Act. So you may still face that challenge later, but for today we are only dealing with the conflict with 18.
Okay. That's Section 19.3. Survive beyond a first course determination, because it's no longer the disputing party, it's now the appellant.
I understand the question, but I would suggest that it remains a disputed party because there's still no agreement on even the court-determined compensation. There might be a different view about it, but that's the submission I make, but the court doesn't have to determine that issue. You're only determining the challenge that they framed, which is it breaches Section 18 and 173 of the Constitution. And the pay now and argue later has been justified in Metcash. Metcash we have included in our bundle of authorities at page 993 of our bundle, and the court will find at paragraphs 59 to 62 of the bundle of authorities the justification for the pay now and argue later based on delay. There's a public interest in collecting. Here there's a public interest in seeing to it that expropriation takes place without unnecessary delay. And it's for the benefit of both. You heard yesterday, if your property is next to a place which is earmarked for a sewerage system, the property values start plummeting. So it's in your interest that if there's going to be expropriation, it takes place quickly and not delayed. On the other hand, is the interest of the public to get the property. And the case we've given examples of in Msiza and Mwelase, both of them were sad cases of transformation delayed. Mwelase was 20 years. That was also painful to argue, but it was 20 years, and Msiza is many years after the beneficiaries had died, when the matters get finalized because of all kinds of delays. They say, well, the delay is caused by the department because you don't have efficient departments, and appeals can be expedited. But Justice Saldanha highlighted an important point that appeals can go to the full bench, to the SCA, to the Constitutional Court. That's more than 2 years, maybe 3. That is delay.
You're going to tell that to the Siale family who've been waiting 100 years for their
Yes.
for their land?
Yeah, I wouldn't say that. I wouldn't. All I can say is we are trying to limit those kinds of situations, but it is no good. It's not a good explanation. Too little, very late. So I wouldn't.
And the ex-court are still in the restitution process.
Yes, Justice Saldanha. That's the sad multiplication of the gross injustice of the past continue perpetuating. And conflicting interests. But the challenge today on 1980 is at least less ambitious than that. Yes, today's challenge is that.
You accept that the sub-8 only targets the owner. Isn't that part of the issue? It's not envisaged here that the expropriation authority will ever be in.
That's true. So was Hafeji. So was the case in Hafeji. It was about the beneficiary. It was about. Sorry, I can't recall now. Hafeji. It was about the owner. It was the owner who wanted compensation, saying you can't allow expropriation before the compensation is determined. And they said that's permissible. So it is true, and that's why the court said it is bad for the property owner, but it's also bad for the state. Let's find a balance. Unfortunately, that's the nature of the transformative obligations of the Constitution, is you must find a working balance. In the process, something is going to be sacrificed. But not 100 years sacrifice, yes, or 20 years. So we.
I'm very concerned about the 100 years.
Yes.
Nakubasio.
Yes.
But Mr. Maniki, the reason why we raise these issues with you,
yes,
is because this matter is being dealt with at a number of levels. You're dealing with it on the legal basis, and there's the legal debate about what the law means and how it is to be interpreted. But there's another level, is how the public understand receptively what all of this means.
Yes.
And are they being informed of the correct understanding to be given to this process?
Yes.
And that's important, and that's why we ask these what might appear to be sometimes mundane questions as to what does just and equity mean.
Yes.
In the minds of ordinary people, it's meaningless.
Yes.
All they want is their land.
Yes.
And if it's land reform, they want to know, why does this process here, how's it going to speed it up?
Yes.
And if the ordinary person is sitting in court today to try to understand what has been happening over the past 3 days, they must either have a sense, if there are people who are concerned or possibly recipients of land reform, to understand that this is a process that makes sense to them.
Yes.
Other than what the lawyers and anybody else might tell them.
Yes.
Especially government officials.
Yes. Justice Saldanha, speaking for myself, and I'm 100% sure I'm speaking for my colleagues, we welcome the questions from the bench, because that's the only way we can try to get to justice, is if we engage in this and try to look at what the right answer is. So nothing is taken in any other way other than this is a search for.
What about today? So.
No, that was just to say that we answered what we were asked to answer by the applicants, but it's not to suggest that other questions can't be asked.
And the public is entitled to understand what's going on in these proceedings.
Yes.
It's an extremely important issue for them. It's a complex issue for us as lawyers and judges. But for them, if we're seriously dealing with issues of land reform and making good the past, they need to understand these proceedings.
Yes. No, it's a matter of survival.
It's us to explain it to them.
Yes, it's a matter of survival. We are one of the most unequal societies in the world. The Gini coefficient, which measures income inequality, shows that we rank amongst the most unequal society. And so matters of access to land, to housing, to resources for people to sustain themselves are critical. And the processes that the Constitution requires have to be implemented. And the public is entitled to know whether the skirmish actually advances those objectives, and we accept that.
And the public says, this doesn't make sense, this Constitution doesn't work for us.
Yes, we must...
Is what the refrain would be.
Yes.
This doesn't work for us.
Yes.
And unless we explain it to them.
And this debate clarifies why it works for them if it is implemented properly. And that the challenge is you're not doing it properly, you're breaching the Constitution, and we're explaining why there is no breach. And that's part of that process. I accept that. And against that, Justice Saldanha, before I get to remedy, I'm left with the failure of the...
You've gone out.
Oh, I'm not left with time. I'm just left with topics. Yes.
Is it going to be long?
No, it's not going to be long. The remedy might be long, but not the publication point. I could close on that, and then it's just the reading in remedy.
Okay.
Yes. The publication point really collapses just on the sections of the Constitution that are relied upon. They say the President failed to publish the Act once he signed the bill into law promptly, and that denied members of Parliament to challenge the Constitution, the constitutionality of the legislation within 30 days under Section 80, subsection 2 of the Constitution. They are conflating two things. Section 80, subsection 2 entitles members of the National Assembly to challenge an Act of Parliament within 30 days of assent and signing of the Act, not of publication, of signing. Once he signs, if there's a basis to challenge it, they can challenge it in court. The publication doesn't preclude them from challenging. That's the first. The publication requirement comes in Section 81. All Section 81 requires is that the President must publish an act promptly after signing an assent. Promptly doesn't mean 30 days, doesn't mean 35 days or 20 or 50 days. It's an unqualified standard. He published in 35 days, calendar days. We submit that's prompt. It meets that standard in Section 81. The difference with 30 days is 5 days. It's prompt under Section 81 and doesn't deny any member of Parliament to challenge, because the challenge is based on signing, not publication. So that challenge really, and is a challenge that falls outside the jurisdiction of this court, because in substance is to say the President fails to fulfill a constitutional obligation of publishing within the time allowed, required by the Constitution. And that is a matter for the Constitutional Court. So I've covered all the other challenges except...
Yesterday is a quintessential.
Yes.
Matter for the Constitution to deal
Yes,
with.
yes.
But you can't get away with it. The Government Gazette is published.
Yes.
The Government Gazette operates here in Cape Town during Christmas
Yes.
and the first week of January.
Yeah.
And, for supporting affidavit to come and say, doesn't work, not correct.
Yes,
And
it is.
that position in an answering affidavit.
So the answer came first. Yes. The correction comes later. So correction comes in reply from AfriForum. So the President's answer, and he says, I'm advised by the official responsible that this was the problem. And the AfriForum says, it doesn't say, it says there was another legislation signed around the same time which was published during the time when you say the government printers were closed. That's the response. That's in reply. We don't file a further affidavit to say either AfriForum is correct or wrong. So I'm here on the basis that I probably can't contradict AfriForum, but I'm saying accepting AfriForum to be correct on the facts. On the sections of the Constitution, there's no challenge of merit, because that challenge is on the basis that the President's publication of the Gazette 35 days after signing the Act is not prompt publication under Section 81. But Section 81 doesn't say the publication must be in 30 days, so there's no breach of the prompt statement. What prompt is in terms of numbers of days can differ between all of us, whether it's 30 days, 35 days or more. That's all I'm submitting. I'm not, and I take on behalf of my client the apology that if the legal advisor got it wrong on the advice about the government printer, that we apologize for. Yes.
Very well. Just that when it comes to apologies, we're going to be even-handed about.
Somebody else must also apologize.
No, I'm just saying they've already apologized.
Yes.
Some have not, yeah.
Yeah, some have not.
Can we pause you until tomorrow morning for your relief?
For my relief only, yes, Justice Saldanha. And I'll try to be quick on the relief. As quick as I promise I'll do my best to be quicker so that my other colleagues stand up.
So it does raise a bit of urgency for us. We have a sense of anxiety about it. So we are really hoping to finish by Friday.
Yes. I will undertake that I'll deal with remedy in 30 minutes at most, and no more than that.
And during tea time, the Judge President asked, if you're not finished, we can run over into next week. We solemnly promised her that we ain't running into next week.
Yes.
We're not available besides
yes.
other crowds.
No, we...
And all of you, I suspect, also have other work to do.
Yes.
So we're under pressure to not teach.
Yeah.
But it doesn't mean that we must then interfere with your time.
Yes. So on our calculation was the applicants and the amici that support them took almost 2.5 days. And on 2.5 days, it will take us to lunchtime on Friday, and they can reply. And reply is not really arguing the case. So that gives us equal time. I wouldn't say equal pay, but equal time. Some said they don't have compensation and left for Pretoria, so equal pay can't apply.
Those who have not been compensated may leave.
Yes.
So, is there any housekeeping that we need? I do not want to repeat yesterday afternoon's.
No.
Ms. Hoffman, you received an affidavit, you know how to deal with it?
Indeed, I'll address it at my main address tomorrow.
Good.
Thank you, Justices.
So you don't have to detain people further. So if anybody yesterday needs to leave for Pretoria, could all you us until Friday afternoon.
Yes.
Early evening.
The early evenings, huh?
Good. Thank you very much. Once again, all of you to the
Perumal Sami. Yes.
Thank you. And then, of course, Mr. Munegi so far. And we'll see you 10 o'clock tomorrow.
Yes.
And that's all. Thank you for adjourned.